Item number 15, review, discussion, and possible action on changes to the board member administrative procedure manual.
If you guys want, I can walk you through each change. Just let me know what you guys want to do.
Sure.
Marcus is going to walk you through the changes.
All right, we can start on the first page. We have revised the date, so it's now reflects August 2018 as the revised date. If you turn to the second
I
page,
object to that change.
if you turn to the second page, we've added Dr. Gordon to our list of board members. And the first major change or proposed change is if you turn to page 6. And so once we're all on page 6, I've identified the changes by striking out the original language and highlighting, bold, underline the proposed language. Does the board have any objections to this first change?
Hold on just a second, Marcus.
Of course.
I didn't get mine since one of my packet wasn't.
Sure.
No, I have it. I just need to. My packet wasn't complete. I have notes on the other one.
She's looking for her notes.
I got it. No, I have it. Yeah. So, we're talking about the page 6.
Correct.
So my only comment about this is the efficiency of the. I mean, I think, and Robert can give us some input on this, that when things come up, it says the board should discuss who the most qualified board member is to make a statement and or discuss an issue. So is there time to have a meeting with the board when something needs to be addressed? If a reporter calls you and needs to talk about something, or if there's whatever comes up, things seem to come up a lot at the last minute, so, or that are time sensitive. So how would this be accomplished? That's my question. I don't disagree with the idea behind it. I just am concerned about how it would happen. About complying with it.
The question I would have I'm sorry, Chair Sergio, would be, what is the percentage of that occurring currently?
I had that answer, but you cut me off.
Please do answer.
In the many years I served as chair, I don't think I ever made a public statement to the media, with the exception of once that Robert let me know about Lazarus down here that was writing a story. So I don't think that happens very often. And I also think that it's certainly in our best interest to not have a knee-jerk reaction in a situation like that and give a statement within a day. So we could easily put out a vote. We could easily make it so we bring it to the executive committee and the executive committee decides. I mean, I just think if there's an issue with the media, depending on what the topic is, we should look at our board members and see who has expertise in that particular area and not by default have it one person or another answering just because of their position.
I don't disagree with that. This doesn't specifically, this is a pretty general area. It's not specifically saying the media. It could be anything. Board members shall not speak or act for the board without proper pre-authorization from the chair and or EO prior to making any statement or press release. So,
When possible.
are you talking about?
When possible.
No, I know, but are you talking just about press releases?
No.
Or?
Making any statement or whatnot. First of all, how often have any one of us been called upon to make a public statement on the board? I think the majority of the times they've gone through Robert. But certainly, if there is a topic that comes up, Robert should notice the board, and I would hope that all of us would know who the most qualified people, respected people are, but at least I would say the executive committee at a minimum should be able to say, this is something good for you, something good for Dion, something good for...
So-
if we have an issue with a public member, certainly it would be foolish for us, for any one of the licensees to have this comment. It should automatically go to Mr. Rufino or Dr. Jordan. Gordon. Sorry.
Gordon, Jordan, Bruce County, these are the things.
That was only one time today.
I think you have to read it in its full context, the both sentences.
Yep.
Right. As well
Just
as,
wanted
I think that there's
clarification.
if there is any statements or press releases, that is something that there should be time taken to properly answer.
I need to address this just from a logistical perspective. We oftentimes, and I try whenever possible to direct media calls through the Department of Consumer Affairs Public Information Office, and because they deal with the media all day, every day, so that's their element, and then they contact me for a response. If necessary, oftentimes it's about a chiropractor who's been arrested or who's recently been revoked, something that for some reason has gotten public attention, and almost always the information we give is purely factual. They want to know what the board's going to do, and often we can't just discuss a pending investigation, but we can give them general information about the process, and so I have this worked out pretty well with DCA's Public Information Office as far as responding. If there were something that required an opinion, and if the reporter wanted a statement from the board, that right now my process would be to contact the chair, and if it is something beyond factual information, to contact the chair, and then the chair could respond or tell me this is what we should say. So in this case, when you say the board should discuss, the problem with that is Bagley-Keene. The board can't discuss, because we'll need to get back to the reporter within a day or so. Sometimes their deadline is that afternoon, and we're not always able to give them an answer within their deadline, but we try. And so I don't think we would have time to coordinate a special teleconference meeting to respond to a media inquiry.
Well, I mean, certainly making a statement in a press release, nobody should be making one individually, as you know, without going through DCA or legal counsel. But if there was a topic that a reporter called on, don't you think it would be in our best interest for you to send out an email to all the board members and say they want an opinion on X, Y, or Z, and have everybody weigh in individually back to you, so there's no violation of Bagley-Keene? So that, you may be able to piece two topics or two opinions together. I just,
Yeah, no, I understand, and I agree, because
it's just we have different people with different expertise, and I just find it ridiculous that we would only look to one or another because of positions. I mean, it just, I don't think it's wise.
No, I understand, and and as you mentioned earlier, it happens rarely, and usually if they're asking for a policy position from the board,
Yes.
and the board doesn't already have one, generally my response would be that the board hasn't discussed this at a meeting, and so they don't have an official position. And so if they're asking a factual, like if somebody has inquiries about chiropractic specifically, and they want to speak to a board member, then I agree. Like if they're asking about something in a certain specialty area, and there's a board member who has expertise in that area, it would make sense to have that board member respond.
So that's this was my comment, and this is what the thrust was, and it was not to question your judgment. It was
No.
to once again give a little more discretion. Somebody calls, for instance, a hotly debated topic that has come up numerous times has been the stroke issue with chiropractic, and unfortunately, we've had it's so poorly represented so many times by people that want to jump on Dr. Oz or want to jump on the show that have poor qualifications and expertise, and we lost a very valuable opportunity. And I would hope
on a board member,
not a board member, but it's happened in our profession, and I would hope that our board, first of all, the less we say, the better. We all, I think, can agree with that, and certainly we should have run everything through legal and the PR. But if it comes to somebody saying, or questioning something like that, I don't see any harm in all the board members sending you an individual email with their comments or statements so that you can pick and choose.
Yeah, and generally speaking, if it's getting really technical, I won't give them an answer if they want. If anybody who contacts the board and wants to know, is this within our scope of practice? We're very careful about how we respond to that because we can't give legal advice.
Sure.
And I don't. It's not wise to give advice regarding hypothetical questions, and you don't know all the variables, and so we try to relay that succinctly, and and let them know it's not that we don't want to help you. It's just that there's a lot of we would need to, of course, consider a lot of different things. So I can't answer that question.
There were numerous times when I served as chair and we had topics come up, or we had opportunities to testify, and as much as it was my prerogative, according to how things were written, for me to testify, I had Julie testify, or Frank, or someone of the sort, because they had a particular expertise in that area. And I would hope that everybody on the board works in that manner. But I also think that, once again, if we write something in there so that at least when possible it's considered, then we won't run into, well, sorry, I'm the chair, this is what I'm going to do, when it doesn't serve the purpose. I mean, if we strip down all the egos, we're all an equal vote, and we're all there to serve the public, and we're all there to serve the administration, and we should learn how to work together so that we can best serve, and not be doing things by default just because I'm the boss.
I think that we are missing the fact that it's already in there when possible. So it's not saying that you should discuss it, you have to discuss it, you must discuss it every time. It says when possible, which is not stricken out.
Can we move on to the next?
I just want to make it clear to the board that we do not have an established executive committee. Although Dr. Azano has alluded to it, there is no established executive committee on this board.
So the three positions are.
No, there's no established executive committee.
So I've been having to sit here the entire time. I could be sitting on the very end.
Well, no, I mean there's
are
board
elected-
officers,
yes.
and
That's what I meant. I'm sorry.
Yes,
Okay.
but
I
yeah,
just wanted to be clear.
certainly you could establish an executive committee that consisted of the board officers, and if there were, policy decisions or administrative decisions, the executive committee could meet, and it would have to be a notice meeting if it's all three officers. But we don't have.
I don't think we need to make anything more complicated than it is. I just think in the spirit of working together, we all have different expertise, and we all recognize those and are careful with our selection.
I'm not disagreeing with anything you're saying, but it's just when we put this in here, and when future boards, this sitting board may have an understanding of this, but when future boards are looking at this, and it says when possible, the board should discuss. So who decides when it's possible and when it's not? I mean, I could see this leading to further debate, and
How would you suggest that being written?
I don't honestly. I don't have a suggestion. It's because when again going back to even if we took out the when possible and said the board should always discuss the most qualified board member, then it raises the question of how much time will that take, and if it's something that the entire board is weighing in on, then it becomes it needs to be a notice meeting, and so that's just time prohibitive, and we wouldn't be able to respond timely.
No,
and if somebody invites us to
Is
speak
it
at
a
an
proposal
event,
to move it out, to take this sentence out? Is that what we're asking now?
I'm not advising either way. I'm just pointing out potential logistical problems and also interpretation problems, because when you put a qualifier in there like when possible,
Well-
then that gives whoever makes that decision the ability to do what they want.
We could
anyways.
wordsmith it, but we could also say there's a potential interpretation problem when people say, "Oh, only the board should say that." That's why I'm the only one that should say X, Y, or Z. So we could, spend hours on this here, or we could, if we all agree that this is a good idea, let's wordsmith it. If we don't agree it's a good idea, then let's so speak.
The other potential concern I have, because again, going back to who makes that call when possible, because we don't get a lot of media inquiries, but probably a couple a month, and usually they're related to a pending case, and the answers are fairly standard. There's not much information, public information we can share about a pending case. So in those cases, I don't consult any of the board members.
Why not go to the executive officers then, or the board officers, and they could.
Still, if it's more than two, because we could say the board chair and vice chair shall discuss who the most qualified board member is. Then that wouldn't have to be a notice meeting, and you'd have two people making that decision instead of one.
I suggest leaving it as it has been written here with when possible the board should discuss who the most qualified person is, given that the DCA.
Again,
I have a question.
Well,
for
again,
legal-
no, I mean, I have to, point out that who decides when possible, because
So
most likely
can we
that
say
person
the
is going
chair
to
and the
be
vice
me.
chair? Can we say the chair and the vice chair?
You have a motion to
I think that would be
Doctor?
preferable.
I have
I
a
make a
question, but
motion.
before,
Oh,
can I
question.
ask legal counsel? Because the majority, 95% of the calls that we receive are usually related to a licensee that's been arrested or some type of pending legal matter. Does that become an issue because most of these usually will end up being something that comes before the board at a later time?
It certainly could become a legal issue, given at least an appearance of prejudging it.
Yes.
A matter that might come.
Yeah, but we're not discussing that. The board members are not weighing in on that.
I just asked a question. I'm just asking a question.
Yeah, so, depending on what the query was about, it could raise that issue.
So, yeah, and again, those are cases, but this isn't specific, and I'm not trying to be difficult, but I'm always looking down the line, and when we have to make these decisions, will this be clear? And so the first thing is that, I can probably say that anything specifically related to a licensee enforcement matter, I wouldn't go to the board because it's inappropriate for them, and also we can't. There's very minimal information we can share about a pending investigation. So the only time I can think of that wasn't enforcement related was when David Lazarus from the Los Angeles Times was calling and had questions about the diabetes seminars and whether a chiropractor could treat diabetes, and so there's and then he called another time and wanted to know why chiropractors are allowed to call themselves doctors, and
Robert,
both of them.
Can I just interject something right here? Turn to page 8 under board chair. It says right here, determines with the consent of the vice chair which board members have expertise in respective areas to act as spokesperson. So are we discussing this for nothing?
No, because that's new too.
Why don't we make the language be consistent then?
Yes, perfect.
Yeah, so
I make a motion that we make the language consistent on page 6 to reflect what is said on page 8, stating board members shall not speak or act for the board without proper pre-authorization from the chair or EO prior to making any statement or press release. When possible, or forget about the when possible, the board chair determines with consent of the vice chair which board members have expertise in a respective area.
There you go.
I'm going to contradict myself.
Oh, man.
If you take
Hold
out
on,
the
I'm not done. To act as
Okay.
spokesperson for the Board of Chiropractic Examiners.
If you take out the when possible, if the vice chair is in Europe or so, or in the
And
Grand
doesn't have a
Canyon and
cell
doesn't
phone.
have
He's
cell
not
phone
able
access.
to do his job, and the next person steps up automatically.
So okay, well
that's-
yeah, I mean, see, but these are
possible.
the kind of things, and I've been dealing with law and policy my entire career. So I always go to these potential problematic things.
Well-
and and because we're all of these issues have become a concern for the board. I just want to make sure that we're all considering the possible implications of what we put in here.
I would hope that everybody has a level of responsibility and enough to let you know if they're out of cell coverage. But in this day and age, I mean, it's really the few times we're out of cell coverage, the next person steps up.
But do you want to leave when possible? Is that what you're saying?
Yes.
And just add the rest?
Yeah, I mean, as much as I don't like the ambiguity of it, I think there may be times where,
Yeah.
and so you're
Can we
trusting.
have the motion
Yeah.
with when possible in it?
Yes, I amend the motion to include when possible.
All right, any more discussion?
Second.
Second, I'll second the motion. Any more discussion? Any public comment? All right. Are we voting on each one of these changes?
That was going to be the question that I was
Yeah.
going to ask.
Well, let's vote on this one, get it done.
All right.
Why don't we just? I'm sorry.
Oh, okay.
Can they just come to an agreement about all these and then vote on them all at once rather than vote on each individual change?
They can, but this motion has already been
Okay,
made
I'm
and
sorry.
seconded, so it should be voted on, and
All
the
right,
rest
let's
of
just
them
vote
after
on
that.
this
Okay.
one.
Aslino, yes. Dane,
Yes.
Lickman,
Yes.
and McLean.
Yes.
Gordon.
Yes.
Marcus?
All right, if you refer to page 8, again, the changes, the proposed language can be identified with bold underline. And so I don't know how you guys want to proceed. Do you want to just go by page? Do you want to go by each change? It's the board's will.
Let's talk about each change and then vote on them. Vote on them as a whole.
Perfect. So the first change is identified in the first bullet point. The proposed language says, determines with the consent of the vice chair which board members have expertise in respective areas to ... The next change is identified at the last sentence, and it says, the best qualified board member should be assigned to the task at hand.
That should say, shouldn't that say the most qualified? Isn't that-
Yeah, best, most.
It's the board's determination.
You're the wordsmither.
Well, while we're at it, okay. So what if the board chair and vice chair don't agree?
Right.
Yes.
I mean, because I'd rather figure this out now than have a situation where the board chair and vice chair don't agree, and then we're going to be discussing again who gets to make these decisions related to appointments.
What if the board chair and the vice chair don't agree on
They
the
should flip a
best
coin.
qualified person? And I'd like to say that the EO should have some kind of input in this as well.
Yeah, but you can't have a vote, so.
No, but it says determines with consent of vice chair
Well, I think
and
previously,
consultation with the E EO.
yeah, consultation would be the appropriate term to use. And
Right.
Well, that's your job, Robert. That's why you get paid the big bucks. If you can't mediate
So I
a
get to be the-
situation, we find
so-
another EL.
so can we put in here that the EO gets to be the tiebreaker?
I think.
I mean, I would think that in a meeting, you should be able to come to an agreement.
Most
Or
likely.
compromise, I mean,
Some
we're
kind of
all
agreement, yeah.
should be working as a cohesive unit to try, we're not going to agree on everything, but certainly that's what we're here for, to learn to compromise and find a resolution. I don't think it's necessary for us to, to tiptoe around that.
Well, we're having this discussion specifically because there has been a lot of disagreement, and it's really
I don't think there's been disagreement. I think there's been a lot of action without any discussion.
And also, isn't this just the role of the board chair? It doesn't mean that the action actually happens. The role is for them to work with the vice chair, is what it's saying to me. It's like this is their job.
So
I don't have any problem with it written like this, with the exception of adding in consultation. And if you want to change best to most, that's sounds a little better to me, but I'm not the.
It matches what the general rules and then
most, yeah, because that's what it says on the other one. So if we change this language because we voted on the other one to match it, it's gonna change on page 6 as well.
Well, I'll make another motion to mirror that and overturn the previous motion, voted upon motion. Can we do that, Ken? What's best so we can move forward?
I think we already agreed that it was gonna match the language.
Okay,
on
good
this
enough.
one. Yeah.
Good enough.
And then what I would recommend, if you're gonna be modifying the language, you may want to use the word after instead of with. So determines after consultation with the vice chair.
Okay.
So that,
You're changing consent to consultation,
No.
which I think is a preferable word.
Yeah.
Yes.
Consent sounds like you need their,
Yes.
you know,
Approval.
yeah.
Consultation. So it would be determines after consultation with the vice chair and EO.
Yes.
Okay. Thank you.
Do you want to go down each list there, or should we just read it? And
We can read through it, and if somebody has a comment, they can speak up. So do you want Marcus to read it out, and then you can just a board member who wants to comment or make a change can.
Well, I mean,
As well continue the
Sure.
way it's been doing it.
Okay, the following bullet, the third bullet says, meets with or communicates with the executive officer and the vice chair on a regular basis.
go ahead.
Any
Yep.
objection? Okay. The next, if you, 2 bullets down, it says verifies and approves timesheets, approves travel, and signs travel expense claims for the EO and board members.
I'm sorry. Can you go up? I know that you're only reading the changes.
Yes.
On one of on the one above that, provides oversight to the executive officer in performance of, of the EO duties. I had one of the changes as along with the vice chair.
If you refer to the next page,
Yeah,
that,
yeah, you put it
that
in
is
under
happening.
vice chair.
Okay, never mind then. So it doesn't need to be here along with the.
No, because this is the role of just that person.
We
Yeah,
can,
but
well,
that
we
person
can-
along-
it's either or, so we can add both or we can leave it as is.
I would
It doesn't
say-
make a difference.
I would say, I would suggest adding it in both areas.
So it's
that
consistent.
it's not
I would say
missed,
so.
and,
that person is involved there.
and then 6th bullet point down, the chair shall establish committees, whether standing or special, as he or she deems necessary. Somewhere later in the document, someone had submitted something that those committees should be established in consultation with I'm not sure who it was, but
Right.
we should just make sure that those languages mirror each other.
Right, so that 6th bullet point that Dr. Azzolino is talking about is conflicting with the very bottom of the page.
Oh,
Where
there
it
it
says
is.
nominates individuals for committee and chair appointments, or establishes committees and appoints chair and members along with the vice chair.
So strike the one at the top because that's
Yes.
replaced with the one at the bottom.
And just so to be clear, the strike through language, a couple bullets down, that was a proposed removal by a member, so that's the proposal. And then if you continue down, the last bullet on the page says nominate individuals for committee and chair appointments. And then this was a proposal from a separate board member, so that's why it says or. And it says establishes committees and appoints chairs and members along with the vice chair.
That language is better than, nominates.
Well, I think
Because
the difference
later-
with the nomination is the chair can nominate people, but wouldn't the board have to confer the nomination?
No, I think later in the language, it states that, later on in the manual, it talks about, the committees and one of the recommendations was that, the chair can recommend that someone, be placed as, the board chair could recommend someone be placed as a committee chair, but that should be, how was it put? That should be more of a nomination and receiving a, approval by that individual before announcing it to the rest of the board. Because just like we were discussing earlier, I think previously the chair was just placing someone in that position as chair without asking if they wanted that position. And I think that it's just professional to ask if they're willing to take on that kind of commitment at that time.
So the language for this can say establishes committees along with the vice chair. And then later on in the document, we can talk about the chairs of the committees, because I think that should be decided within the committee.
True, not a bad idea.
So establishes committees along with the vice chair.
In consultation.
Or,
with the vice
yeah,
chair.
right. In consultation with the vice chair.
To the top of the next page, it says establishes a two-person committee / subcommittee and or task force to research policy questions when necessary, along with the vice chair and secretary.
So that's gonna be a noticed meeting
So that would be problematic, yes.
to establish a two-person committee.
Correct.
I would suggest again, say, in consultation with the vice chair and executive officer establishes two-person committees, so on and so on. And then take out that last clause or sentence.
Let's repeat that.
So it would say, in consultation with the vice chair and executive officer, establishes two-person committees / subcommittees and or task forces to research policy questions when necessary.
Agreed.
So you're taking out along, in consultation with the vice chair on that one as
No, we're
well?
taking out along with the vice chair and secretary. If we have vice chair and secretary in there,
Right,
it
I
becomes a
understand.
notice meeting.
So, but you're taking out both of them, or are you leaving
No.
in vice chair?
We're leaving in vice chair, just moving
Okay.
it into the first sentence.
Okay.
So it would be one sentence, because that's actually not even a sentence, that along with the vice chair.
So we're under the roles and responsibilities of the vice chair. The first bullet remains, the inclusion from the previous iteration of the
Yeah,
bullet.
I want to revisit that for a second, because I just want to be clear. I don't have, because I serve the entire board, I'm appointed by the board. Typically, and I'm confident that this is the case with all DCA boards, the chair serves as the direct supervisor of the EO and gives direction. I don't have any concerns with the chair consulting with the other board members or with the vice chair, but to have two people giving me direction, possibly conflicting direction. I would want to know that the vice chair and the chair are on the same page before I get direction, because that would just create confusion. And usually, most of my duties I just do. I don't need, I don't. But there's things like signing off on my timesheet and so on. So I just want to make sure that we're not, again, down the line, that we're not in a situation where the vice chair and the chair both think that they have authority based on this manual to give direction to the EO, and they may not be on the same page.
Does anybody want to?
Previously, that's why it said along with,
Well,
we said along with, not,
who put that out
But
there?
I agree with Robert, it shouldn't be along with, you should have one boss.
Yeah, I agree, unless whoever put it out there has, tell us why.
So can we
So,
just,
so the person who,
so can we just remove it? If there's no
well,
objection?
the thought behind that, I think, was to, in sharing the duties and collaborating and relieving some of all of the numerous duties on the board chair. I don't have a problem with it being moved back over to the chair.
or I personally, because I'm not, it's not, for me, it's not a matter of who gives me direction, because you could take that responsibility completely away from the chair and give it to the vice chair, and that would be fine. But I would have one boss. So, but if it's a,
Isn't most of that stuff happening in the open meeting anyway?
most of my direction comes from board meetings.
Right.
There's not a lot of specific direction coming directly from the chair. But that's kind of almost part of the duty statement, and it's just understood in DCA culture that the chair serves as the supervisor or the person who gives direction to the EO, and in most cases it's like approving time off or signing off on timesheets or travel expense claims. It's not really saying you have to do this or you have to do that.
And then the vice chair is the backup, right?
If the chair is unable to,
it's-
then it would go. Then it would fall to the vice chair.
And that's where you can take some of the weight off of the chair. If the chair needs support and help, they can ask the vice chair for help.
Yeah, but it's really, there's not much direction that's given her. It's not very time consuming, so.
No, because
We're gonna
and
eliminate that.
I just want to clarify that if the chair was giving me direction that I didn't believe was on the same page with the rest of the board or was inconsistent with what was discussed at board meetings, I wouldn't just blindly follow that. I would make sure that the other board members were aware of the action we were taking. So it's,
Now, just because you typically play devil's advocate, you would do that, but if someone else were in your position, how would you recommend that we formulate language so that doesn't occur now that you mention it?
you could put something to the effect of direction or direction given to the executive officer must be consistent with policy directives discussed at open board meetings or public board meetings, something to that effect. So that you don't, if you had a chair who wanted to go rogue, they couldn't just start telling the EO, I want you to do this, I want you to do that, I don't care what the board thinks. That's because that's a matter of, I know, that's not something I had to be told. I know that my responsibility is to the entire board, not one member of the board. And so to the extent that, the one member of the board who may be giving me direction is, in line with what the other board members think and have decided, I'm not going to question the direction I get. But if I think this seems, problematic, I'd probably discuss it with the chair first. and say you might want to run this by the board before we do this. And if they were resistant, luckily I haven't had to face that, but I would probably speak with legal counsel and share my concerns and determine how to. But that's one of those things. When you're selecting another executive officer after I leave, that's one of those things you need to make sure that the person you hire understands their ethical obligations, and because it's not your typical job, serving 7 bosses, and in dealing with all that comes with that. So you need to make sure that the person understands where their duties lie and when they should raise a red flag.
I'd like to make a comment on that. The law recognizes 2 types of decisions: the policy-making function that the entire board exercises as a body, and then the ministerial implementation of those policies. And so the chair has the inherent authority to take actions that implement overall board policies, but the actual creation of policy is done by the board as a body. The executive officer serves at the pleasure of the board, and so the executive officer ultimately has to answer to the board, and any direction given by a chair that was inconsistent with board policy would be beyond the authority of the chair. So all those, the law recognizes all those sorts of potential issues and has solutions for them already. I think being overly prescriptive in a procedure manual like this could create unintended consequences. And so long as the executive officer has a single person, the chair, that he or she reports to in a supervisor type relationship, should be sufficient, because the policy formulation function rests with the board.
So I think all this discussion has come to the conclusion of eliminating that second bullet point.
Alright, if the following bullet point says coordinate the EO annual evaluation process, including contacting DCA Office of Human Resources to obtain a copy of the Executive Officer Performance Evaluation Form, distributes the evaluation form to members, and I think this should be collects the ratings and comments for discussion.
No, it's
No
collates.
collates.
Oh.
And that just got moved from chair to vice chair, same language, right?
So, shouldn't that go right back to the chair for the same reasons?
No, because it's just administrative.
Yeah.
All right,
It's-
well,
yeah,
it's-
okay, leave it there. I don't have any problem with it.
Following says attends meetings with legislators.
Yeah, I'd
And-
say, I'm gonna cut you off there, Marcus. The next 2 things we should strike because we already determined that language under board chair.
Establishes committees and appoints chair members.
I think we should,
The language should be the same under vice chair as it was under chair. For both the next 2.
maybe you could say works with the chair to
Well,
establish.
it just would be the
All right.
mirror
It's the
officer,
mirror
or the mirror,
image.
yeah, image.
All right. So that goes for the next 2 things.
And then the last one says oversee assignment of board member to serve as a liaison to the organizations listed. And if you go
Page 26.
That's just moving that's just mirrored what was already on that other page.
Yeah, I just want to make sure that the board members see the list. And so if you refer to page 26, that's the list that's referred to on page 9.
Right, but the language on page 26 says this process shall be overseen by the vice chair in consultation with the chair, which is not what it says. Under the vice chair, just says oversees assignment of board members to serve as liaisons to organizations listed in chapter 7.
Then just add in consultation with the chair.
So while we're at it, should we strike that out from under 26 or just leave it in there? It's okay if it's duplicated?
I think it's fine to cross-reference.
Okay, alright, good.
Okay, under the duties of the secretary, these were established prior, but calls the roll at each board meeting and reports that a quorum has been established. Calls the roll for each action item, approves board meeting agenda. And
That
then
should be in consultation.
Consultation with the chair and EO, correct?
Yeah, that's how it is now, and so, this is just,
And then the last one says, assist in establishing committees/subcommittees and notifies members who have been recommended for these.
Agreed, we were gonna get rid of that
yeah.
up at the top of the page.
And then there's been an inclusion of a section for committee chairs. And it says committee chairs approve committee agenda, chairs and facilitates committee meetings, and reports the activities of the committee to the full board.
That's good.
I'm sorry, just technical, that you need to make those plural, so approves committee
Of
agendas and facilitates committee meetings.
Alright. The next change is if you refer to page 12.
11, actually, you have one, it just says and secretary.
yeah. So if you refer to page 11, under agenda items, that first paragraph,
Yeah, I don't think you need to put secretary in there, given it's going to come through the EO and back to the secretary for
I don't
approval.
disagree. These are just board members' suggested changes.
I think it's redundant.
Okay, we
What
can
do you guys
strike.
think?
I'm fine. We don't need to add that in.
Okay, if you refer to page 12. Again, this was included at the prior meeting. It's a section clarifying the necessity to comply with Bagley-Keene.
I have a question about this.
Of course.
It says Bagley-Keene Open Meeting Act prohibits a majority of the members. So the understanding is more than 2, which is not a majority.
That just says it's written in the law.
Well, then it's
We've been told wrong the entire
hard
time.
to
Ken, can you clarify that?
This is literally what it says in the law.
In Bagley-Keene?
The definition of a meeting
Mhm.
is where you find the requirement for notice if there's more than 2. So it's the way the law defines a meeting. So you're saying this, you pulled this directly from the code section,
Yes.
right? So the apparent inconsistency has to do with the source of the requirement that a meeting consists of 2 or more persons,
Okay,
or more than 2 persons, I should say.
more than 2. Okay.
So do we have to directly quote Bagley-Keene? Can we make this clear, that Bagley-Keene prohibits more than 2 members? Because technically that's the law. If you have more than 2 members participate in any discussion or deliberation, then it's a meeting. And so,
Can we
That's not
add a
the law.
line
You
in-
can add
Can we add a part in this section that
a
says,
meeting is considered.
Or one way of solving that problem would be if you remove the reference to, because you're not purporting to quote this, so you can remove the reference to majority and then put in both subdivisions as references. So you could say that it prohibits more than 2 members of the board. From meeting. Then we could just insert the other reference to the other subdivision that talks about meetings.
Alright. If we can move along to page 18.
first section should probably stay as it is, because the act doesn't allow the changes in the language that were suggested.
Shall we put in the new suggestion of nominate during the last?
You want to put in the new election procedures as section in there?
That's once we, no, I'm just saying, right here, to put in that officers of the board shall be nominated, but the election still stays the same, but nomination, we'll just put
But
the.
why wouldn't we
Put
put all
the
the
entire
election
thing.
procedures in
That's
the,
totally fine.
yeah.
So we follow down under the titles communication between members.
But we don't need this so that they can be mentored by the incumbent, right?
No, that's gonna be,
Taking that out, right?
Yeah, just to be clear, we're removing this, like we'll leave the first sentence because it references the fact that we shall elect on the first meeting of each year, and then we'll add in the election procedure following, correct?
And is the title of this better
It may be
phrased
amended
election?
election of officers. That probably would be most appropriate.
Yeah, election procedures.
Okay, so communication between between officers. It's a pretty long paragraph, so for the sake of time, I'm going to skip down to that last sentence. It says, if all parties agree that communication cannot be resolved, any board member may agendize the ongoing concern and, if necessary, call for a special election at the next full board meeting.
Do we have any other provisions that provide context about the special election, what that's referring to?
No, there's no special election. That's pre-existing language, and I don't think that there's a reference to a special election any other place in the manual. So I don't know specifically what that's referring to. Maybe Robert does.
No.
Do you think it means a special meeting?
It's referring to election. I thought we already got an
Yeah, this
opinion
doesn't
on
make
that.
it doesn't
Yeah,
make
well, this is just board policy, so it has no effective law, but
It
it's,
doesn't
yeah,
make
it's
any
interesting
sense.
that it's,
Well, I'm fine with making the change of any board member.
Question about the special election.
Well, I'm wondering if it's what it's referring to as a special meeting.
but it says at the next full board meeting. I think, given that if the determination is that you can't have a special election, then I think you would just need to end this sentence at, if it cannot be resolved, any board member may agendize the ongoing concern
Did we ever
at the
get
next
it?
full board meeting.
Did we ever get a very definitive opinion that a special election cannot occur? And do we have valid
And we have a
defensible
call
ground
for
to
a
stand
special
on
vote.
to say that no, it can't be?
I mean,
Yes,
has
there,
to be
there was a
something
written
to it.
opinion in that regard that was
Something happens to.
distributed.
Yeah, call for a special vote or something like that.
If the purpose of the meeting would be to recall an officer, then that's been dealt with in an opinion.
so the sentence would need to read, any board member may agendize the ongoing concern at the next full board meeting.
Well, they can agendize a concern, they don't have to wait till the next board meeting, they could contact the EO.
Well, that's what it already says above it. If it can't be worked out with the EO, then it's gonna have to be discussed with the whole board.
Well, there's, I mean, we have elsewhere in here that,
Yeah, I mean, I think this is referring very specifically to a special election, not to a meeting.
Because it tells you it's gonna be at the next board meeting.
So what's the legal opinion, Ken?
The legal opinion was that there was no ability to recall an officer, specifically the chair, during the period of time between elections.
And that
But this-
was your
that's-
conclusion, or was that, I just need to, I'm sorry, but
That was
was that,
a written opinion from the Legal Affairs Division.
But that doesn't address the repetitive failure of someone fulfilling their position, is that correct?
This section is related to communication between officers.
Right.
So it's talking about the interpersonal communication between the board members. So
But
it's
it
just,
also states, failure to respond to email correspondence or failing to address specific topics is inconsistent with professionalism, and if a repetitive failure to communicate persists, this will be discussed. So it's talking about failure to do your job.
Talking about failure of communication.
I mean, I just,
That's part
I'm
of
still baffled on how anybody gets elected and can hold a position and not have any, be subject to recall. I don't think that happens in the United States, but
Well, the appointing authority is what you look at here, and if there's an issue, the appointing authority is the governor. And so I don't know where what the history of this reference to special election is, but it's inconsistent with the legal guidance that's been provided this year by the Legal Affairs Division.
So would it be a better choice to put in there something about discussing it with the governing authority or the appointments department or?
or leave it and get another opinion
I-
5 years from now.
but I think we can. I think we could say, if all parties agree, communication cannot be resolved. Any board member may agendize the ongoing concern for the next full board meeting, and if necessary, notify the appointing authority.
Okay.
under committee appointments, it says that the chair shall nominate board members for committees, or the chair and vice chair shall establish committees, whether standing or special.
I think
Did we
have
not
language
already-
about this.
Yeah. Approved language in that regard?
Yeah, this is just a cross reference, so we'll want to mirror the language under the responsibilities.
The next paragraph says the composition of the committees and the appointment of the members shall be determined by the board chair and vice chair. The chair may consult with the vice chair or secretary and the executive officer. The chair should attempt to refrain from serving on multiple committees unless no other member is available to serve. All conversations must be consistent with Bagley-Keene Open Meetings Act restrictions, which mandate that no more than 2 members can actively discuss board business.
I think you need to strike out "or secretary," the last paragraph on page 18.
Doesn't match
Yes.
the language from before.
Did you want to add in there, I think someone mentioned about the committee members choosing on the chair for that committee?
The chair of the committee should be chosen by the members of the committee.
Committee members decide on the chair. That's what's-
We could adopt the same voting procedure there that we've adopted for other officer positions.
It's just 2 It's just committee.
It's just two of
Yeah.
them, so they just point at each
But if
other.
there's three people.
Yeah.
And for committees, do you guys want to leave it chair, vice chair, or chair, secretary?
For a committee,
Yeah, what do you think's best?
it's just chair as a member. I don't think it.
No, he's talking about the consultation.
Chair, vice
Oh,
chair,
oh, oh.
consultation,
Alright,
yeah.
Yeah, leave it as such.
Yeah.
Can I just ask this or ask be addressed? What about removal of chairpersons?
Well, if chair, if committees are decided between chair and vice chair, then any changes in the committee would be with the chair and the vice chair in consultation with the EO.
Because the committee assignments aren't addressed in law. The problem we have with officer elections is that the law speaks to that. The law doesn't speak to committee assignments, so it's fine to just let the chair and vice chair, if there's an issue with any committee, to address that accordingly.
But I guess my question is, the committee chair is decided by the committee. So you're saying that removal of that committee chair or change in that committee chair position should be decided by the board's chair
Oh, you're
and vice
talking
chair?
about the committee chair?
Yes.
Yeah, that should be decided within the committee.
Within the committee.
Yeah.
I guess if they can't resolve it, they can
That was my
bring it to
Yeah,
the.
that's internal committee stuff. And if they can't come to an agreement, then I guess they would talk to the chair, the vice chair, and the EO.
Then that should be put in here.
Okay. Did you get that, Marcus?
Okay, the next change is if you refer to page 20. The fourth paragraph down, it says, the board chair designates one member of each committee as the committee's chairperson. The board chair.
We decided to change that already.
Okay.
That's gonna be an internal decision with the committee.
Do we want to repeat that
No.
on this
Yes, because this is talking about committee
committee
meetings.
meeting,
So just mirror it here.
Marcus?
We can refer to page 22.
So I'm sorry, I just want to be clear. Are we striking out that whole paragraph on page 20?
Yeah, we're gonna mirror.
Yeah, so we don't need that under this heading. We're just going to take it out.
I just want to make sure.
Okay, and if you refer to page 22, Dr. Azzolino identified some ambiguity and incorrect language in the law. We sought legal counsel. He provided us with an opinion related to board member addresses. And so it now reads, board member home addresses and personal cell phone numbers are considered confidential. However, this information may have to be disclosed in response to a subpoena or records request. And we've stricken, which was the language of contention, where it said, request for DMV confidential status may be submitted on the completed DMV form to the executive officer who will sign the form.
I'm fine with the language, I just have a question. When would you get a subpoena or records request for a board member's personal information? Don't know.
A disciplinary
Yeah.
matter.
Yeah.
Oh,
Yeah,
got it.
it's unlikely. I don't recall it in 10 years
just-
that I've
But
been
it could
here.
happen.
It could. And so, if we're required by law to
Of course.
disclose something, we have to.
Of course. Okay.
Okay, then next page 23. Under press statements and contacts, I'll skip to the second sentence. It says only the board chair only the board chair, executive officer, or one of the designees are authorized. That's redundant. are authorized to publicly represent the board to the press or news agents and report. This is very,
Yeah, that's,
yeah.
Pretty much same,
Won't this
Think
go
we already
back to
hashed
one
out
of the
earlier.
first
Yeah.
things we stated?
can we just say, refer to, what's the prior section?
It was on page 6.
General, third bullet.
Got it.
Rephrase it, page 6.
Got it. So if you guys are willing to move on, we can refer to page 25.
So, I'm sorry, just want to make sure
Of course.
I'm clear on what we decided. So for press statements, are we going to leave press statements and then just lift that language from page 6 and move it here?
That's
Okay,
what the-
just want, okay, because I had suggested deleting that whole thing, but then I thought better of it.
Okay. So if you refer to page 25, these two have come up from previous meetings last year. We've added language and we've discussed it in the past. Does anybody need to review this language? And that's the last proposed change.
No, there's page
24,
26.
Oh, yeah,
I have a question,
of course.
when is the sunset review? I thought that was every 2 years.
Every 4 years.
4?
So that's
So
it.
we're changing strategic plan to every 4 years?
And that was discussed last year when Dr. Eldrin was on the board.
I just, for, on page 26, to be consistent with an earlier provision, it says if the matter is not resolved, any board member may agendize the matter at the next board meeting. Should we add, and if necessary, notify the appointing authority?
Yes.
There you go.
Dr. McLean, did you have a remaining
Well,
question
can I-
regarding the previous topic?
No.
Can I say something? Any board member may agendize the matter for the next board meeting. Because you can add something to the agenda.
Yeah, you don't have to wait for the board meeting, you can get it on the agenda for.
For,
the
it's
next
for
board.
discussion at the next board meeting.
Same thing with the previous one.
I just, something just jumped out at me and I'd like to propose it while the board's here. So on page 27, resignation of board members. In the event that a board member chooses to resign, the board member or the executive officer should notify the governor's office of appointments. We probably should just say the executive officer should, because if that member resigns, we have no control over what they do or don't do. So we'll just make it a, if somebody gives me their resignation and doesn't notify them, or whether they do or not, I'll notify the governor's office.
Do we need to make it specific and say maybe verbally and in writing?
Well,
Or
well,
that
actually, what
implies-
we should say is that the board member, because really they should personally,
Send a letter.
because the governor appointed them, so they should
Right.
personally notify the board, the governor, but they don't always, and so in that case, just as a backup.
And
Why don't we
or
put
the,
and the executive officer?
Yeah. Yeah, I think if we just change that to and, that would be good.
We need a motion to accept the changes.
I'll make a motion to accept all the changes that were discussed regarding the administrative manual.
I'll second the motion.
Any discussion? Any public comment? Call for the vote,
Azalino, yes. Dane,
yes?
Whitman,
Yes.
Kane,
Yes.
and Gordon.
Alright, thank you. discussion, possible action, on board member committee assignments. So there's a couple of changes and I'd like to explain. There were multiple board members that were serving on more than one committee. And we had a new board member that wasn't on a committee. So Dr. McLean and I are in the thick of things with our CE regulations. I was on 2 committees and Dr. McLean was on 2 committees. Mr. Ruffino had resigned from the Governmental Affairs and Public Relations Committee, and Dr. Theon wasn't on a committee, so.
Mr. Rufino resigned as chair. He actually asked to be on the Government Affairs Committee.
Resigned from
No,
the
he resigned from the
entire
committee.
committee and wasn't on a committee. And one of the, I wish Mr. Ruffino was here, he had suggested on the agenda today that the Chiropractic Act be put on there, which is something I also knew you had an interest in, Dr. Esley, and I thought that would be a good fit for you two to work together, and Dr. Theon on governmental affairs. That way everybody is on one committee.
Yeah, I would suggest that Mr. Rufino would be excellent on government affairs also. And given it's government affairs and public affairs, maybe we have Dr. Gordon and Mr. Rufino both on there.
And then that means Dr. Lickman would move to enforcement.
And I wouldn't mind working with enforcement, just
The only thing I would say is that would be 2 public members on one committee versus working with,
We could make it a 3-person committee also.
Well, then we're back to,
one person.
we're back to,
I also,
You have the authority to make just that one, 3-person committee. And just for the record,
Or we could take Dr. Gordon with us on enforcement.
well, you could potentially flip Dr. Gordon and Mr. Ruffino if they're both amenable to
I just
serving
think
on the other committee.
so I'm fine with government affairs, I just wanted to point out that we wouldn't have a DC on there. And if
that's
Frank would want to
necessary.
be on, and I'm not sure if it was necessary or not, so.
I think
I
that
think a license.
There should
would
be
be
on each
important,
committee.
yeah,
definitely
would be important for
would
the,
be important because
absolutely.
previously I served on there and there's instances where they definitely need interpretation.
That's what I'm-
But he also has a lot of expertise in that area.
Yes,
I don't
so
know
I think
about-
Frank would be excellent in there as well. Don't get, I'm just saying.
Yeah, and I don't know about his expertise
No.
versus yours, Dr. Gordon, but certainly among the rest of us board members, I think he has greater expertise with the government affairs.
Well, I'd like to have a discussion with Mr. Ruffino about his, well, I guess if we're gonna do a special committee on the act, that's something that you can
And just,
talk to him about.
just for the
My
record,
concern is that he agendized that very specific thing. He's not here to talk about it.
Yeah, I don't know why.
So, I'd like to have a discussion with him about that, because that's a good fit. It's a good fit for that committee.
But it's a special
it is.
committee also, so I don't think that
Well, I
needs
was
to.
hoping it would be taken up in enforcement, but since we voted on doing a special committee,
and
we
I
can talk to him
had
about that.
previously stated that I was very interested in that very, the special committee as well.
Sure.
So-
Which is that? I'm sorry.
On
then
act.
we should do that.
Yeah, I don't know what Frank's interest is in that, so
Well, then-
I think we should just speak to him on
Yeah,
that
I
and
will talk to him about the act.
decide. Because I
Um,
think Dion can be a great adjunct in that regard.
So I will talk to Frank about that and we can establish a special committee on it. Since he is not going to be, the enforcement committee is not gonna be taking that up, which is specifically why I put him on there, because he agendized the act.
Jeff, didn't he request at the last meeting that he wanted to be placed on the Government Affairs Committee?
Right, he also, I mean, I'm trying to distribute the workload, unless he's gonna be on the enforcement committee and the governmental affairs committee. So I'm gonna switch with Dr. Lickman's approval, Dr. Lickman on the enforcement committee and Mr.
No.
Because we can't have 2 public members. Dr.
Then can I make a suggestion, Madam Chair?
Sure.
That you, talk to have your discussion with Mr. Rufino and then propose that you revise the committees at that time versus going back and forth?
Yeah, I'll talk to him.
Because I think that the Government Affairs Committee, particularly with all of the legislative things that come up, it might be a good idea to have 3 people.
Well, in a public setting, since if I'm gonna be speaking with Frank, I won't be able to be speaking with anybody else. So I'd like to speak, Dr. Theon. So since we need a licensee on the Governmental Affairs and Public Relations Committee, are you interested in serving on the Enforcement Committee at all?
Not really.
Okay.
Sergio's not that bad.
Should I take it personal?
Alright, that's what I want to know. Thank you very much. Okay. And then one more comment I want to make about the next page. I know that we had just spoken about chair of committees being decided by the committee. Since committees are likely to change a little bit, I still want to have that standing that since the governmental and public affairs committee is going to change a little bit, they would decide in the committee once that's established who's going to be their chair. Okay, so let's move on to number 20. Review, discussion, and possible action regarding CBD.
No, maybe you're.
Yeah, 17 and 18.
What am I doing? I'm skipping over. Sorry. Number 17. Review, discussion, and possible action regarding distribution of board meeting materials.
So this item is in response to an agenda item requested by Mr. Rufino. The staff provided a general breakdown on our timeline to prepare materials for the meeting. So we just wanted to make sure that the board knows that we do have an established process and we do our best to comply with the timelines. However, there are a couple of things that can cause a delay in your receiving the packet in a timely manner, such as delayed or rescheduled committee meetings, delays in approval of the agenda, and also external things such as receiving information from, say, DCA budgets, legal, or legislative staff. So we just wanted to be clear that there are things that contribute to the materials coming out really late.
Can I just say and request or recommend that in the event of delays that the entire packet not be held up, that at the very minimum that we receive an electronic version of it in advance, as close to 2 weeks as possible. If, as stated previously, oftentimes we get this information the week before, and given as a professional member given the task of really analyzing, as you can see, I go through these things multiple times, as do most of the board members, I'm sure, along with practice and everything else. It would just benefit us so that we are able to do our best and most thorough job if we have as much information in advance as possible. It doesn't have to be the entire packet, because if it's just one committee, I would hate to see the whole thing held up for that. Or, one section, I would hate to see, but I would trust that we could still begin with something.
So just in response to that, the only thing that will conflict with that also is if there's a delay in the approval of the agenda. So that usually is about 10 to 11 days before the meeting. So the materials and things are not finalized usually up until that point. So that's another thing to consider.
Right, and that goes out separately.
That does go out separately.
Yeah, the
But
petitioner's
If
hearing.
there's a proposed agenda, that I struggle with this.
I can make a suggestion. There's certain things that are standing agenda items that we know are going to go on there, and those, to the extent, unless it's something where certain statistics, we try to make them as relevant as possible, and and compile them as soon before the meeting or as close to the meeting as we can. But as those things are available that we know are going to be on the agenda, we can afford to forward them on a flow basis electronically. And And then things that aren't certain, if we have them available electronically once the agenda is approved, we can send those. Because
That would be helpful because I think the things that are special items, like the administrative manual, was done already, right? So that is something that was more time consuming. The stats we could look through quickly. We don't need to see that, but
And is it not the case that although the agenda is approved prior to it being posted, so it's posted 11 days prior, so it has
we've been
to
doing
be
10,
approved.
correct?
so we try not to post it, on the, 10 days prior. We try to
You
post
can't.
it as soon as possible.
11 days.
I'm sorry.
It's no later than the 11th day before the
So
board.
that's what I'm,
Yeah.
the reason I'm saying that is that, again, I'm going back to I think the requested time was getting the material 2 weeks in advance.
Yes.
Typically, I'm sure that you guys are done with it prior to the 11 days because you wouldn't finish it on that same day and post it.
So
right?
we try to provide or get the agenda approved 2 weeks prior to 2 weeks prior to the posting date, and so that gives us time to provide it to the chair and the secretary, and then also get it approved by legal counsel. So sometimes, depending on when we get the responses from all the approving authorities, it takes time, and so the sooner that we get it approved, the sooner that. But one of the things that we try to wait for is that inevitably, more often than not, there's a change between, say, if we get it approved 7 days before the posting date. Inevitably, the last year that I've been doing this stuff a lot, things change and things have come in at the last minute. So, I don't have an objection. I don't think we have an objection to providing it to you guys. I just wanted to let you guys know that there are things that prevent us from being able to complete and sending things in a timely manner.
So again, I'm appreciating that fact.
Yeah.
It would be very helpful if we could really work hard on meeting that deadline and getting it to us so that we have it and can analyze it in a appropriately. And I think that if it comes down to something, we all understand that there are changes that can be made, and we're flexible enough to adapt to those changes. It's more so to get the bulk, more important to get the bulk of the material. Then we can be more fluid
Perfect.
in making changes.
Not a problem.
And can I make a suggestion? I don't know if it's possible or not. I serve on another board, and we use Dropbox and Box.net, and we've secured a box, so information just goes into Box, and then it's not so much about the time frame of getting things shipped out and put together and all that. So if there's some information that we all would have access to a Box account that we all can sign in and download, whatever.
Look in the Dropbox and see if there's anything in there for us to look at.
Right, and we'll just get a notice saying materials are now in Box.
It's something to consider. We have to consult with legal counsel on
Yeah, I
that
know
stuff,
you
but
have to
it's
see
something to
it.
consider.
But it is something, and it saves us a whole lot on printing as well. We don't print our stuff anymore.
Yes.
Now, I do still like the
I do
printing.
like the
Yeah.
printed because I make
But,
notes, yeah.
but yeah, because it's so much easier with notes and flipping back and forth and remembering and tabbing and that sort of thing. I'm just saying to get an electronic to copy
least
ahead
read
of time,
it
to
ahead
at
of
least get started.
What are you doing with that iPad there?
So I had
Okay,
it,
don't-
but I won't go with it.
We're on camera.
All right. We done? All right, now we're on to number 18, review, discussion, possible action regarding legislation from other states. Again, this is something that Mr. Ruffino wanted these three items to be reviewed, which they were. Some of them mimic things that we already have in place, so not sure without Mr. Ruffino here what the discussion was meant to be around this.
Did he discuss it with you guys at all?
It mirrors a lot of California law.
Right.
And it's not specific to chiropractic. I I can't see any reason. I don't know if there's a suggestion by Mr. Rufino that the board is doing something inappropriate, and he's pointing to other state laws that address that. But I don't see anything here that
We're not already doing.
that
For
we're
the
not
most
already
part,
doing.
yeah, with sunset review, with our DCA oversight,
Not sure.
yeah.
Yeah, he didn't give any explanation why he wanted to discuss these things.
So we'll move on to agenda item 19, review, discussion, possible action regarding revision to section 330.1.16, the curriculum requirements, which we don't.
Oh.
We didn't provide any materials for this
No.
agenda item. We just wanted
What's
to-
the agenda item? I'm sorry.
Curriculum
19,
requirements.
we just wanted to allow the executive officer the opportunity, should he feel necessary, to explain any recent changes or discussions that have happened regarding curriculum.
Yeah. So, and we discussed this pretty thoroughly already under the earlier agenda item about the act. So the schools have they've gone through all of the regs and provisions in the act related to curriculum. They've identified provisions that are problematic for them and recommended changes or striking the provision, and the majority of them would require amendments to our regulations. There are some that, if we wanted to pursue them, we would need to amend the act. So
But not the majority of them, correct, Robert?
no, the majority of them would just be regulations, not the act. Yeah, there's a few things that would require an amendment to the act. So it's we could do a lot of them just through regulation and not amend the act. There'd be some that we wouldn't be able to do unless we amended the act first. So, and we discussed how to proceed with this. I mean, do we want to make, if we're going to pursue the regulatory changes, do we want to elevate the priority of this and have us focus our staff resources related to regulations on this? And we would. There's still a lot of information we need to get from the schools. There's discussions to be had. So
Why don't we plan on getting that over the next month or two so that we can have a report back to the board,
getting what?
the information from the schools that we
Well,
can get and work with them to
It would require a meeting with board members, preferably licensee board members, and the schools and staff. I mean, because we need the expertise of the licensees when it comes to.
well, that was the idea of the special committee, so.
Yeah. So, but we would need to include the schools in that.
Sure.
And hammer out any misunderstanding or confusion.
Well, why don't we schedule
Excuse me.
that?
Well,
Okay.
I have another question. I know that the materials that they've given us are, helpful to know what changes they want, but not really in a regulatory format. So,
That and also the
and with the substantiations.
the explanations they give are, some of them would be sufficient. They're, for the most part, they're brief and they explain why they're problematic for the schools. Through the rulemaking process, the standard is pretty high for justifying any changes we want to make,
Right.
and we need to explain the necessity, and we need to look at the potential fiscal impact and economic impact. There's a lot of information we still need to gather, and also it needs to be this board needs to look at each of the provisions and make sure we're in agreement with.
Right, so my question is, the next step would be to have board members and the schools, or maybe right now, since the schools already provided their stuff to us, start with board members looking over those changes to see what we agree with and what not, and then involve the schools and define it further, and then move to a process that would put it more in a regulatory format? Is that
Yes,
what
I
needs
think
to happen?
I think
Okay,
that's
that's
best
what I wanna make
done
sure.
through a meeting, so.
No, I got it, I just wanna make sure what the next steps are.
with
So-
members present.
Yeah, so are we talking a board meeting or a committee meeting?
No, I'm talking a committee.
Committee meeting with the,
Committee meeting.
or a special meeting with the
With-
school, the 3 schools present, and,
with us, with the board and staff, looking over what they've already given us, and then meeting with them once we narrow down, once we've looked at what they've given us, meet with the schools and have another meeting. So that's the
To
plan.
be clear,
Okay.
two board
Two board
licensing
members, right. Okay, all right, I just wanted to make sure the next steps. Sorry, Robert, was there more you were gonna
Well,
say
no, I
about
don't,
that?
do we want to, because I know this is a priority and we want to move on this, do we want to identify those members now, or when, how will we, because.
Yeah, I think we need to discuss it.
Because
and-
there's a lot of material to review.
I know there is.
And we had already started discussing it, and we didn't get very far. Yeah, there's questions and potential disagreements come up early. So it's probably going to be a lengthy process.
didn't you send out you sent the document to, we discussed it in the meeting.
I sent
Dana,
the
myself.
document to all of the board members, and I know, and we discussed it with Dr. Dane. We had a meeting with
Yes.
you and Dr. Dane. Yes.
So.
So is that the only document you're referring to, or
Yes.
did
Yeah,
they
that's
send
the
more?
document,
Well, I think we could chip away at that.
right.
Oh yeah, we can. I just want to.
We can talk about putting together a 2% committee for that.
Do we need
Okay.
to talk about it? Can we do it?
We can do it.
I'm just trying to move this along here.
Yeah, and because if we do it now, then that part's done, and then we can move to scheduling.
Well, I know that you are interested in the act. I mean, I still see
I'm
these
interested
as
in
two
moving this
separate
forward
things,
here.
so am I.
I don't see
So
them
I
as
am
two separate
gonna-
things, once again, because one's predicated on the other. If we could
As a
achieve what we,
public member, I do see them separate, the act and the schooling.
yeah, but the act regulates the schooling.
Not all of it.
It does, but the act, the most that's in the act is not necessarily just schooling. When you're looking at the act, you're looking at a lot of other
Yeah, but the
things in
idea,
chiropractic as well.
sure, the idea once again was to move this along and see how far we can get without touching the act. And if we can achieve all the appropriate changes that the schools wish in the consideration of protection of the public, then we leave the act as is when it comes to that, and then we
That's
review
why I
the
think
act from a
it's-
different
That's why I
perspective.
think if you have two different people looking at the curriculum for the schooling versus the ones who are looking at the act, then you won't focus on the educational part of the act, which might make you want to open the act. If you look at the act as an overall, do you really have to open it versus trying to see how to
Well,
work
realistically,
with that education?
just haven't been in practice for close to 25 years, knowing this profession, the act is not getting opened up.
Well, that's why I was
anytime
confused
Um,
with the agenda item and the vote we had earlier with having this special, committee on the act, when that's not really what we want
That's
to look
not
at.
the
We want to
issue,
look at the curriculum
That's
soon.
regulations.
Well, I apologize, but I didn't see that agendized as the curriculum.
Yeah, I was just, and that's kind of what I'm saying. I'm sort of like, since you really don't want to touch necessarily the act,
Well,
why not
I
have a
wouldn't,
committee that really focuses on the thing that you want to move
but
forward
I
with?
think in essence, it's the same spirit. We got to look at the act and see how it's not contemporary. And it's not contemporary in regards to a lot of things. Number one being education, number two being scope of practice. And so,
But if we have no intention of amending it, why are we having?
Yeah, for
a committee?
purposes
well,
of this
because we
agenda
could pass
item.
regulation to better clarify things like we're doing with education. We're not amending the act to pass regulation to better clarify what they can do and can't do in the school.
So my question is, do we want a special committee, and I'm gonna use the language that's in the agenda, a special committee to open the act, or do we want a committee that's going to look at the curriculum regulation items? Because I think that's more, I just think that is more what we're talking about here. And in that curriculum discussion, we can talk about the act, but there's not a reason to have a special committee to talk about opening the act if that's not anything we're considering, because it's gonna cause widespread panic among licensees. And I'm not opposed to having a committee to look at the act, but if that's not what we're gonna do, let's have a committee to look at the curriculum.
Well, I'm not sure what Frank's idea was.
Well,
but
right, I'm not either.
As much as it may cause widespread panic among licensees, I think the declining numbers should be causing widespread panic among licensees.
Well, then I think we need two different things. I think if you're gonna look at the act in regard to, declining licensure and defining scope but if there's no intention of doing anything to it, because you can't change the act through regulation.
Well, in essence of just trying to move things along here, I don't want to get caught in semantics of what these committees, one or two committees may do. I think it's work that can be done. It can be done in one committee. We could break it up into two committees, or we could deliberate on this for another couple board meetings and have the schools really get frustrated that we're not moving along on anything.
I think that ultimately, initially, the committee is going to, part of the act is the curriculum, so the committee would have to look at that.
I agree. When we're looking at the curriculum, you can look at the
So-
act, but there's no way that you're gonna
So-
amend the act through regulation.
Right, so
I would like to put a
ultimately-
committee together to talk about this curriculum regulation, because we need to move it along. My suggestion is gonna be that Dr. Azzolino and myself are on the committee to look at the curriculum regulations. If we wanna put together a different committee to look at the act, I'm totally open to that. But if we don't need that, I'm fine with that too. So that's the suggestion.
Do you need a motion, legal counsel?
Dr. McLean, do you have interest in looking at a committee
Well,
on that?
because I consider that all the same, all a part of what we would be doing. That's where my interest was, all of that, because while it is essentially two separate things, depending on how you look at it, ultimately, they're intertwined. And so, in order to get to one, or prioritize which one to get to, we have to evaluate the act in order to,
If I
as
can
well.
offer the staff perspective, from an organizational point of view, this has been identified as the priority.
Yes,
Curriculum.
It has.
Not any of the other issues in the act. Curriculum has been identified as the immediate priority. We need to look at curriculum. Everything else in the act is a distraction. So I think we should focus on
I
curriculum.
wouldn't say it's a distraction.
Well, on the same
It's
level.
from this
if-
agenda item, it is.
On the same level, if Mr. Rufino suggested this and Dr. McLean has interest in this, why don't we have them do a special committee on the act there? We can handle the curriculum,
Okay.
and just this way we can move things along.
Good. Done.
You okay with that, Dr. Gordon? I know you had interest.
I like it, especially because there's a public member on the act, which is what
Well,
the
he,
public is asking
And it's his interest.
anyway, and it's his interest.
I'm sorry?
I think it satisfies everything that you want to get done.
Okay.
I think it's something I'm interested in too, but go ahead.
You could get on there too.
No, you can only have two.
Well, we could have three. It just would have to be noticed
Just
meetings.
stick it to two and
I mean, you could still review the act and send in your opinions,
I
because
know.
trust me, I'm not gonna be sitting
I know.
back. My fingers are gonna be working, sending emails to Robert. I just won't communicate with him.
Part of the problem though,
I know
if you have the spoken wheel type communications
Yeah.
about anything, then it becomes a meeting, even if a member is not on the committee, but the member's communicating about committee business.
If he's sending it to Robert, that is spoken will, if Robert's,
Well, if it's not a public,
Okay.
if these aren't publicly noticed and they're feeding, a board member is feeding information through me to the other two, then you have three board members that are.
my
so it-
understanding is this is only an informational committee to research and to come up with ideas before establishing whether it be a three-person committee or bringing the agenda before the board for discussion.
Yes, it'll come
However,
in
we're
front of
doing
the board.
research. I mean, nothing's happening. There's no action items here.
True. Yeah.
The committee conducts business though, and that's what triggers the requirement.
So I think we'll let them do their
Okay.
part and we'll do ours. It'll come up, everything's gonna come up in front of the full board for discussion. everyone will have a chance for input.
Okay.
Alright, let's move on to the next agenda item. Number 20, review, discussion, and possible action regarding CBD.
This is something that we at the board office, we get a lot of calls and emails on our Chiro Info email line asking about CBDs and whether doctors of chiropractic can use them in their practice. We're not able to give them an answer because, one, the law is not clear, and we can't give legal advice. So, but it is something that is obviously of specific or particular interest to the profession, and so the board doesn't necessarily have to go into a deep discussion about this, but we thought we'd put on the agenda, see if any board members have any suggestions or opinions.
I think it's premature considering that the feds are still looking at it as a regulated substance. I think it's safest. My recommendation would be that the board tell chiropractors to stay away from it at this moment because the law is too new. I mean, I don't think in the state we even know how to handle it.
Yeah, well, yeah, and we, from the board office, we tell them that, we're not able to give them advice. We don't tell them they can't use them because the law doesn't say they can't, federal law maybe, but we don't tell them they can, and we direct them to discuss it with an attorney if it's something they are considering doing. So, we have to.
I think it's worth reminding them that it is still federally
Yeah, and
illegal.
I do when
Okay.
because sometimes we pretty much give them a we can't give legal advice answer, but some callers aren't satisfied with that, and the call will get elevated to me, and then I have to give them the long explanation of why we can't give them legal advice, and so I explain to them federal law and everything. But it's
Ken, do you have any
Well,
input on this?
there isn't an overarching opinion that's been prepared by the Legal Affairs Division for all the boards and bureaus of Department of Consumer Affairs. A great deal of uncertainty exists. The fact is it's still a Schedule 1 substance under federal law, and you'd hate to be the board that provides the wrong guidance and ends up being involved in protracted litigation over the propriety of the guidance. So my recommendation is to continue handling queries from licensees the way that the executive officer has just explained that he does.
And so if somebody is to have discipline for this and go through the whole process with an administrative law judge, would that decide some sort of precedent on it?
That would not be precedential, but if there was an appeal from a board decision to a court through a petition for writ of administrative mandate, and then that trial court decision gets appealed to the Court of Appeal, that's when you'd have a precedential decision that would be could be applied to, assuming there's a published decision, could be applied across the board. Otherwise, any other decision short of that would not have a precedential effect.
So I'm just throwing stuff out here. So let's say someone did have formal discipline for this, and an administrative law judge, that it went that far and they didn't get any discipline from it. Would that be an interpretation of the current
would that be seen as tacit
regulations?
approval?
No, because
Okay, that's
it's
what I wanted
it's
to know.
on a case-by-case basis.
Yeah.
Yeah, so
Okay.
the board would not necessarily be bound by it.
Okay.
The other thing to keep in mind is the issue may come up in two different ways, in a discipline case or in a probation case. And when there's probation, there's an order to obey all laws.
Yeah.
So that becomes an issue. If there's a disobedience of federal law, it could be a ground for violation of probation. the mere use of a product.
Right.
So it depends in part on the context that comes up, but if the decision of the board would not be precedential in any way, it just applies to that particular case.
I'd like to, I'm just curious because we often make decisions on enforcement matters based on the outcomes in prior, even though it's not precedential. And so if we were to discipline someone and ultimately we weren't able to successfully discipline them, then would we need to continue to move those cases forward, even though we know there's a likelihood that we're not going to prevail in that matter? Sorry, just
The board would not be obligated to cease until there is some sort of a court order saying that you can't apply the law in this way. If there's a published decision that was adverse to a ruling by the board, that would only apply to that case, but then you would interpret future cases using that precedential decision. If it was not a published decision, even if it went up to the Court of Appeal, it would give you guidance on what the Court of Appeal might do, but the board could continue acting as it did, and an interested party could file a case for an injunction to prevent the board from applying the law in that way. But that's all very hypothetical, but that's the sort of thing that would be required in the absence of a precedential decision by the Court of Appeal.
And I'm supposing that, and I know I'm not insinuating in any way that we can slop this information over to our board, but the medical board has got to be dealing with the same confusion because of the federal illegal, even though they can do anything they want with medications, that because it's illegal federally, they're in a quandary as well.
It's more complicated because they're prescribing.
Yeah,
Yes, but
Yeah.
it's safe to say that we're probably
Okay.
not going to be having the same questions in a year from now.
Yeah, well, I can tell you this, that there are, they're looking at the law and policy from many perspectives, but there just isn't an overarching opinion of the legal division that could be used to provide guidance. And so it'll have to be on a case-by-case basis if it comes before this board.
Okay. Thank you, Ken.
Hi, good afternoon. Sonia Logman from Business Consumer Services and Housing Agency. Just given this is a particular topic of note that falls under our agency, I feel compelled to just give you a couple updates on where we are with the regulation for cannabis. There are 3 licensing entities in California, and I'll just sort of go broad here, not knowing sort of where each of you are in background on this particular issue. 3 different licensing entities here in California. So the Department of Public Health regulates manufactured products, or everything that turns that leaf into anything else that you might consume, a tincture, a CBD type topical, an edible. We also have the Department of Food and Agriculture, which regulates obviously the plant itself and the cultivation of that plant. And then the Bureau of Cannabis Control, which is your sister program under Department of Consumer Affairs that has the pleasure of regulating all of the other pieces. So we have embarked on a regulated legal commercial cannabis market. We have recently published our permanent regulations. Those are out for public comment at present and will come to an end in near end of August. Based on some feedback, we may be likely to go out for another public comment period, but we'll wait to see what the attorneys say there. And that goal is to get to the finish line of having permanent regulations in place by December. We were fortunate enough to have provisions in the MCRSA, which is the Medical Cannabis Regulation and Safety Act, which really sort of realigned what was the first medicinal act that passed in 2015 and our 2016 proposition. And sort of those were very, very close, but not quite the same. And so the legislature kindly sort of brought some reconciliation to both of those in the framework that we're operating under now. And we are operating under emergency regulations, which will expire in December. So it's sort of all of those timelines and pieces. So as you continue to do your work, we are looking at the sort of definition of consultation. Your programs, your executive officer, and others have brought this up to us. And as you, or as Mr. Swenson mentioned, legal counsel hasn't furnished an opinion. But of note for you, I know that there is a bill that's circulating, and I can work with Marcus to get you the actual bill numbers because I'm not quite savvy enough to rattle those off, with regard to veterinary medicine and the ability for a veterinarian to actually consult with a patient, and that's mostly because we are seeing CBD-based products already on the market, that sort of claim that they're hemp-derived, which is sort of a whole nother beast that we've got to work through. But just so that you're aware, that is one piece of legislation that is floating that obviously we're paying attention to. And then next to that, also wanted to point out to you that there is a pharmaceutical product that is pending FDA and DEA approval. It's called Epidaurus. It's specifically used for two types of epilepsy in young children. The legislature as well as the governor recently signed that bill. So should our federal counterparts make a disposition on that, we would have the opportunity to prescribe and dispense that here in California. So just wanted to give you those few updates as paying attention to your conversation.
Yeah, thank you so
Thank you.
much.
Of course.
Thanks for coming. Okay, we'll go on to item number 21. Review, discussion, and possible action regarding telehealth. So, Ken, what can you tell us about telehealth?
And just a little background, this is another one that we do get, not a lot, but we regularly will get a question about, can I practice via telehealth? And the simple answer is yes, the law allows chiropractors to practice via telehealth. I guess the more complicated question, something this board may want to consider at some point, is what would be acceptable for a chiropractor to do if they're treating a patient, as I like to say, telepathically, even though that's not the appropriate term. But if they're treating them remotely, what can they do and what would they be prohibited from doing remotely? And so I don't know if Ken has any thoughts on this.
Well, the memorandum for the agenda item identifies some provisions that apply to the Medical Practices Act. The Chiropractic Initiative Act obviously didn't contemplate telemedicine because it's from 1923.
22.
Thank you. But the idea here is that because it wasn't contemplated, there's no conflict, and so it, more likely than not, depending on what the specific provisions would allow, would not conflict with the Initiative Act. So therefore, regulation would probably be a suitable means for implementing governing authority for provision of chiropractic services remotely, because it's not conflicted with anything in the Act. And so it's something as a policy issue the board could take up, and I think implement regulations to cover if it desired.
Well, yeah, my questions would, we're allowed to do telehealth, but then there's the whole other question is, are you complying with the requirements of a proper exam through telehealth? There's questions about treating things that are within our scope, but in the course of chiropractic treatment. That's there's been questions about that. So those would probably be all things that would have to be spelled out in a regulation.
It specifically have to be covered in a regulation.
Yeah. Okay.
So it would be a great deal of work to put together a set of regulations, but the board would retain control over the language of the regulations. It's been granted that sort of authority by the Initiative Act, and so it can, in that sense, the Act wasn't static. The board can make changes within its jurisdiction to conform with changes in technology, and this is one example where it could do it.
And I want to point out that this isn't something that we've had any issues with thus far. I don't believe we've received any consumer complaints related to telehealth they received from a chiropractor. However, given the volume of calls we're receiving, I think this may become more common, the practice, and so we may start getting more questions or getting complaints related to something that happened in the course of being treated through this method, through this technology.
I would suggest that we probably have our plates full right now, and if we don't
Yeah.
need to take this on, we don't.
No.
We don't need to, and certainly things may change over the next several years in this regard.
Any other discussion or public
I
comment?
would point out one thing about that. It may, some aspects of the issue could relate to curriculum and education. Preparing practitioners for the possibility of doing that sort of
Okay,
provision of services. So it may overlap with that.
all right. Thank you for that suggestion. We're going to take a quick bathroom break. Real quick though, 10 minutes, I'll come back.
Value.
Gonna get some public comment on number 21, telehealth.
Hi again, Steve Jaffe, SCU. Just had a question, because the way I understood it is Mr. Pulio was saying that telehealth is within scope or within, that there's nothing that precludes it?
No, the law, the Business and Professions Code, allows chiropractic, the chiropractic profession, among most of the other health professions, to practice via telehealth. So there's no law prohibiting it, but it's up to this board to determine if something is within the scope of practice. So if somebody, even though the profession is allowed to practice via telehealth, if in the course of doing so they exceed the scope of practice, then they would be subject to discipline by the board. So there's there's those things to consider, and given the nature of chiropractic and what people typically think of as chiropractic being a hands-on profession, it seems like it wouldn't lend itself to telehealth. But there probably are many things that a chiropractor can treat a patient with remotely, and so then it's just determining what is appropriate, what shouldn't be done via telehealth. There's a lot of those questions that may come up if the practice, as technology expands, if the practice becomes more regular.
Okay, because the first thing that hit me was practicing across state lines, because you have no idea where the patient you're talking to is.
That's another issue. That would be, if you're licensed in California and you're in Nevada treating a California patient, that's probably okay. But if you're treating a patient who's in Nevada and you're in California and you don't have a Nevada license, then you're violating their law. So
That's exactly what I was going to bring up. Okay, thank you.
Thank you. Any other public comment? Okay, we're going to move on to item number 22, review, discussion, possible action regarding definitions of chiropractic adjusted technique and chiropractic manipulation technique. Dr. McClain.
So, in an effort to keep moving forward with our continuing ed regulation and the changes that we were making in the continuing education committee, we just wanted to get a pulse on the board's interpretation or definition of the difference in the two, or if you feel that there is a difference in the two, to enable us to categorize things appropriately. So I just wanted to get some discussion and feedback on those. And if you have extended discussion or feedback, feel free to email Robert and he can send it to me. But anyone have any input in there along those terms regarding the definitions?
Did you want to, I'm sorry, I should have asked you beforehand, but do you want to combine this discussion with number 23, or should we deal with everything? It's totally up to you.
It's probably easier if they're separate.
They're separate.
I don't have a strong opinion one way or another, but it seems like the majority of the world is using the term manipulation, and it's only chiropractors that are using adjusting or adjustive, so.
So when we were discussing adjustive techniques, we were talking about some of the adjuncts that enabled you, and also we wanted to find out from the school's perspective of what they are calling various techniques that are like AK, for instance. Is that considered it's not considered a manipulation technique, but an adjustive technique or a chiropractic technique. And so those were kind of that's kind of the mindset to what we were looking at as far as categorizing things and getting perspective from other professionals.
Wouldn't it be safer to just refer to those as chiropractic techniques and not adjusting or adjustive or manipulation? I mean,
Well, the problem-
KSOT.
The problem comes in when we're defining what qualifies for continuing education units for adjustive technique. That's why this discussion came up.
Because we want to put things, we want to narrow these categories so that we don't have, narrow the categories, or I'm sorry, not narrow, but define the categories so that people aren't able to try to slide in just the whole array of things under, you know, I don't want to say that word, but a whole array of things. If we define it, if we have definitive language, especially for staff to deal with, then they can better assess the situation when it comes to some of these very general, broad spectrum requests that we're getting for continuing ed credits.
Can I ask a question? And so from our point of view at the staff level, for us, when we interact with these CE providers, manipulation and adjustment are used synonymously, and that was kind of like the impetus for this conversation, is that for us, like, if there is a distinction, like it's important that we know. And so that's why just to start. So, I mean, that's just the start of the conversation. So, does the board agree or disagree whether or not an adjustment and a manipulation are the same thing?
Close enough.
Close enough, even though
Close enough.
like the diagnostic was a CMT code, which is a chiropractic manipulation technique, but I don't think that makes it still could be set either way. So.
I think they're commonly used interchangeably.
Okay, and then a chiropractic adjusted technique, is that the same thing as a chiropractic manipulation technique?
It can be, and it
Can be. Yeah,
Because
that
it's
was
not
the
mutually
question.
exclusive.
That's the question, that's the dilemma. So give us some examples of when you say it can be, and give us some examples of when you think that it's not appropriate.
well, AK is a perfect example. You may be doing something that is not actually manipulating the person.
Right.
It's not an adjustive technique, but it's a chiropractic technique.
So any of those non-force techniques or non-mobilizing techniques, I guess, would be the better terminology, or I'm just throwing some things out there. Feel free to jump in.
And that's where the next question came up. Do we want to give chiropractic adjustive technique CE credit for something that other professions can do besides chiropractors? So they kind of one question came out of the other one. So when we're talking about chiropractic technique CEs, do we want to approve things because it comes in front of staff all the time that other professions
You have to give an
can do?
example because
Well,
technically,
the one we got stuck on was AK.
okay, because technically manipulation, a physician can do a manipulation.
Well, all right. People with
Physical therapists are doing it.
people
I'm
with
sorry, what was AK?
Applied kinesiology.
people with unrestricted licenses aside. So if a massage therapist can do it, would it qualify for chiropractic adjustive technique?
No,
So
in my opinion, no.
So
Manipulation of soft tissue.
yeah. So This was a perfect example of, not that, staff isn't somewhat knowledgeable, but non-chiropractors like Dr. Gordon, they have no idea how to define these things. When people say this is a technique, how are they supposed to define what a chiropractic manipulative technique is what we're trying to help them with.
And I actually reached out to the schools about this in preparation for this meeting, and I got two different opinions from two different schools, whether AK was a chiropractic technique or not. I said, in your opinion, is it an assessment protocol or is it a chiropractic adjusted technique? And I got two different answers.
Well, if you ask LifeWest where they don't teach AK, they're probably going to give you one answer.
So one of the things we had discussed at the last board meeting with chiropractic technique was, and I'd have to pull up the exact language, I have it here somewhere, was chiropractic techniques approved by colleges, and then so chiropractic adjustive techniques or chiropractic manipulation techniques is taught in CCE accredited colleges or specialty boards accredited by the American Board of Chiropractic Specialties. So that's where this discussion started, when we were having a meeting to bring Dr. McLean up to speed on what we had talked about at the board meeting. If we as a board still agree that that's a good designation, then we're going to have to take things in the gray area, because some schools, they say AK is a technique, which is fine. Then we're going to have to accept that, even if we think maybe it isn't an adjustive technique and other professions can do it. So I just want to make sure that we're all still on board with this. I'm sorry. That we're still on board with this definition, and Dr. McLean probably has some other comments to make about it.
Well, first, let's answer the question at hand. So basically, the consensus is what? I know you started, Corey, and Dr. McLean, you started to say something, and
I'm sorry.
I'm fine with the definition you provided.
Are you fine with the definition there?
I think both agencies are well vetted and credentialed, and therefore it's very definable.
And you think including adjusted technique and chiropractic manipulation techniques it's good, both of them?
To include
Okay, have
both
both
of
of
those.
those. I think so.
Sure, 'cause
Yeah.
you're never going to get everyone in the profession to agree upon
Okay.
the appropriate terminology. That's for 2022. We're close.
So basically, we will leave the language as it stands on that. It's for mandatory
But
hours.
I think Dixie has something here.
So what you're saying, just to be clear, is that if any of the colleges, the chiropractic colleges that we approve, say this is an adjustive or a manipulation technique, we will give it blanket approval.
Yes. Or if it's something that's being taught through a specialty board or approved by a specialty board,
Then it would get
and, as you mentioned, American Board of Chiropractic Specialties is overseeing those things, then yes, it should be approved.
So you know what? One thing that we discussed in the last meeting that isn't included on here too, we expanded this to not just be in the core curriculum of the chiropractic colleges, but taught as an elective
Yeah.
or a club with an academic advisor.
Sure.
So we will need to do the research on each of our chiropractic schools to figure out
You can get a
what,
list from
Not that many.
You
okay.
can get a list. You're gonna find a lot of repetition.
Are you only talking about the chiropractic schools, or are you talking about anyone who provides CEs?
No.
Talking about the chiropractic colleges anywhere, any of the CCE
approved chiropractic college.
in the
Okay,
country,
not
and there's
the
one
ones that we
in Canada.
looked at today when we approved
Those are CE providers.
Those are just providers.
Yeah, those
Okay.
are the schools.
So
Right.
those are not, okay, but you wouldn't just say anything that they would say.
No,
we're trying to
Yes,
define
exactly.
what they're.
That's
Just
what
to
I
give you a
want.
little background, what we're doing now is we're trying to revamp, on the continuing ed committee, we're trying to revamp the guidelines to which we approve all of those people that are
Okay.
coming through. And so that's why we're going through this.
Okay.
Yes.
I just wanted to make sure there was a distinction between the schools and the people who could pay some, like I could pay and be a school right now.
No.
No.
So,
Yeah, because you wouldn't be
No.
accredited by the Council of
CC.
Chiropractic
If I had
Education.
CEs, right.
No.
No.
CCE is the organization that
Sorry.
accredits
The
the
schools.
schools.
There's something called the Council of Chiropractic Education, CCE, which is different than CE, which is continuing education.
That's what I'm saying,
Yeah.
though. The CEs are the
Just providers.
certificates, right?
Yes.
Like
Those are
certificate
just the
providers.
people who wanna give a seminar. They
Okay,
are not, well, sometimes it's a school, but they are not all school.
I just wanted to make
because they're
sure
on
that
list.
what you're saying is it's only the chiropractic schools that you're accepting, adjusted
Chiropractic
technique
schools and specialty boards.
And specialty boards.
Got it.
What we're saying is that the CE providers can only teach techniques that are taught in a school or approved by the specialty boards. So the schools don't have to be the one teaching the CE, but the CE providers can only teach those techniques that are generally accepted.
Got it.
And again, I just wanna make clear to the non-board members that are here, this is still topic of discussion. This
Okay,
is not something that's decided, this is something we're discussing.
okay,
Cause I can see people going, making notes like, oh, this is new, this is what's happening. No, we are talking about this in the bigger picture of, amending CE regulations.
all right. For an authoritative text on chiropractic technique, it's chiropractic technique, principles and procedures. It's a 496-page book. It's in its third edition, I believe. It's written by Tom Bergman out of Northwestern Health Science University and Western States Chiropractic College. They have chiropractic adjustments, they have chiropractic joint manipulation, soft tissue manipulation, and includes, where is it? Traction and soft tissue techniques. So, there's a whole list of 3 different pages of techniques at the back of it, but I didn't want to break copyright. So you can buy a copy of this book for $115.
Can I,
I can, I'll leave it with you.
thank you.
Kendall, can you not give us a condensed version, a summary?
I can send you a link where it's posted by a university in Yemen.
Wow.
What else comes with that link?
They must get your social security.
So the next, did we cover, where's the next one?
So the response for 23 is yes, right?
Yes.
The response for 23.
Yes.
So the answer is, well, I think
I mean, if they're teaching something that's approved, for
No, no,
instance,
right.
a Webster technique, right? Other practitioners can do it, a nurse can do it.
So the question came in committee as to whether or not we should approve, or we should be the body approving a technique that can be taught by other non-chiropractic professionals.
So,
No, the question was, should we be approving for adjusted technique things that other healthcare providers would do? Not like, this isn't really our realm, this is someone else's realm, they should teach it. I'm saying, should we approve for adjusted technique, something that other people could also do, even though we probably do it better?
That's kind of what I was saying, so I guess I didn't articulate that properly. Anyway, so that's what we were trying to decide or determine or ask opinions on whether or not we should be approving, or should we relinquish that or send them to the other specialty. What was the example that we used?
It's probably AK, right?
No, we were still, this was under the conversation
Yeah.
of AK. Still,
But there was
because I think you were talking about some TMJ stuff that we talked about.
Yeah,
That
that's
wasn't-
what we were
But that
saying.
wasn't what this question was specifically about.
What, the 23?
At least that's not what the question that I had.
Okay, so I think we have two different questions.
Yeah, so why don't you get opinion, because I know what I know what you're talking about, and I think it's important to bring that up as well.
So one of the things that we discussed is, for an example, just to get your opinion on, if there's a course that a dentist is teaching on TMJ, should we be approving that for CE, continuing ed, under the chiropractic continuing education? Should they be allowed to get continuing ed under chiropractic for that?
Or should we make them get continuing education approval from the dental board?
That was just
Well, they
an
have approval
example.
from the dental board, it's gonna be irrelevant to our license.
Well, they don't, because we can still take CE from other healthcare boards and get credit for it.
According to the new guidelines that we discussed.
It's in a law now.
I mean, are you looking at approving that for an adjustive aspect?
No,
Or are you
no,
looking
we're
at
not
it from a
talking about-
physiological aspect?
We're not talking about adjusted technique anymore, we're just talking about, so Dixie is presented with a seminar on TMJ, and she's like, well, how do I know if this is a qualified person to teach this?
Is it approved by the dental board?
No, they're just asking for us to approve it as the chiropractic board.
So
Okay,
Dixie,
well, I mean-
can you give us some other examples?
Well, they would
of what
have
you
to
were
be approved.
talking about?
They would have to be approved by some regulatory body.
No,
Well-
that's just an example of that, to give you an idea of what we were thinking about. I don't know if you can think of other instances where that will occur, or Dixie can give us some other instances that has occurred for her.
So for TMJ, I've had both sides of the scenario. I've had one that the instructor was a dentist and applying for a course on chiropractic adjustive technique for TMJ. And the dentist is the one performing the chiropractic adjustive technique and wanted us to approve this course.
And we,
Tell them to trim the name chiropractic and just do manipulative technique of the TMJ.
And I referred them to the dental board. That, I don't know what a dentoscope is, but in our laws, it says, chiropractic manipulation or chiropractic adjustive technique. And
Well,
so
he
I'm
shouldn't-
looking at our scope.
Yeah, he shouldn't be
Um,
using the term chiropractic,
It's
but
not
a dentist
chiropractic.
can manipulate the
Well-
TMJ. So if he has something meaningful that chiropractors can learn from, why not?
He can be approved by the dental board, but I'm saying, I'm getting this from a lot of professions. I'm getting
My vote on that
hormone
would be-
replacement therapy,
Okay, my vote on the
stuff like that,
dentist- My vote on
Uh-huh.
the dentist would be, if he's approved by the dental board, then we should be able to offer that. But
That's not,
That
the
wasn't-
question
but-
is.
if
No.
he's not
Should
approved
we,
by-
as the Board of Chiropractic Examiners, approve that course as a chiropractic adjustive technique course?
Taught by a dentist.
we
taught
don't know
by a
if it's-
dentist.
I mean, without it being vetted appropriately, it may be great, but how do we know?
That's why we wanted to go by the dental board.
So the licensees can still get credit for that course if they get approval from the dental board. I have no problem accepting that, but me, with the chiropractic laws and regs and no knowledge of the Dental Practice Act, I don't feel that I'm
So what's the
qualified or
hormone
we are qualified to approve that course. I mean, same thing goes for hormone replacement therapy and a lot of other things I get that are in like,
But who's teaching the hormone replacement therapy?
I've had numerous applications for that.
For their medical physicians or naturopaths?
They open it to naturopath, it's,
But who's teaching it, a
oh,
chiropractor?
no, they're usually medical doctors and,
But that would be outside our scope.
right?
So why would we can't?
Because there's
approve-
nothing in our law that says they can't. That's why I'm asking.
No, there is.
Well,
We
I mean-
can't administer hormone replacement
No, no.
therapy.
I mean, there's nothing in our law that says we can't approve a course that's outside of our scope. Chiropractors can't perform that, but should they be coming to the Board of Chiropractic Examiners?
They should.
Maybe it's because our CE fees are low or whatever, they're looking to get approval wherever they can get it.
Sure.
Should we be the ones evaluating and approving that for CE? I don't feel that we are the
Well,
ones that
first of all, I
should.
think we cannot approve anything that is advocating any practice outside of our scope.
And that's something that needs to be added into our guidelines,
Mhm.
point blank. That
And it doesn't
any
mean,
procedure, technique that is out of the scope of chiropractic will not be approved.
And so when it comes to manipulation or adjustive technique, I get a lot of things where the lines are blurred. Is it, they call it technique, but is it diagnostic techniques? Is it manipulation techniques? Is it physiotherapy? Is it, I get everything under the sun under that category, and so that's why we're looking for some clarification, because there's a lot of contention in that area between the board and the providers submitting the apps.
Well, I think the clarification will hopefully come if we have some better vetting procedures on those individual providers. Because if you have a top-notch university that's teaching something that's going to be of educational value to the chiropractor, then that should be covered.
well, then again, keep in mind, chiropractors can take hours from courses that are approved by other healthcare boards, so we don't need to be approving that.
Yeah.
So, and I think the language that we
Well, yeah,
have as far as
I think that's a
technique
valid
goes
question.
will cut down on a lot of it as well.
Because before they were just able to try to fit it in under just technique, but now once we distinguish chiropractic manipulative technique or chiropractic,
Well, the law is very specific right now as to chiropractic adjustive technique or chiropractic manipulation technique. But it seems to be, I'm getting a lot of applications where it's kind of the lump of patient care all put under chiropractic adjustive technique, and it's everything from the examination to the diagnostic testings to the manipulation or the adjustment to the aftercare and the exercises, the rehabilitation. So these are just some examples of what I'm seeing.
And that's why we're trying to specify it as far as taught in a chiropractic college
Mhm.
or approved by the specialty board.
So
Hopefully
I
that'll
have
cut down.
another question.
Yes.
What about CBD and opioids?
We're not there yet with CBDs.
If it's approved by another healthcare board,
Yeah, but they can't use it. What?
but again, then
can
that
still
would
take
fall
it.
until it is just like we just said, once we change the guidelines that no, there will not be approval on anything that is not within our scope, and anything that is not legal would not be in our scope here yet. Anything that's not in our scope here in California at this time.
But
However, I'll go.
I was gonna say, but using chiropractic to treat opioid addiction, there are multiple ways.
Yes,
To do
there
with
are.
that.
Well, but
There
yeah,
are.
but that's not,
That's different, I think.
if that's what the class is.
Yeah.
When you say opioids.
Yeah, you just said opioids. I thought
I'm
you
just saying the
meant-
topic. So again, we get requests a lot of times, at least through Chiro Info, about the appropriateness of data. The question that they ask is, can I teach a CE course on opiates and on CBD? That's the question that we get asked.
See, but it
Well-
depends on how the verbiage of that, on prevention of, or pain management as an alternative to opioids, it has to be utilizing chiropractic or something within the scope of chiropractic.
It's not supposed to be easy, don't worry.
But, so back to the question at hand was whether the board should grant continuing education credits for adjustive manipulative techniques that are not limited to a doctor chiropractic. The answer, the opinion of the rest of them.
Well, I think you have to answer yes, because there's other licensees that can perform all these manipulations.
if it's approved, if it's a technique that's approved taught in a chiropractic college or approved in a specialty board.
Yes.
Okay, all right. Good start.
I'll see you have searching us. And I just been looking all over. I just
Any public comment? Okay, move on to item number 24, which is review, discussion, and possible action on BNP section 1054, name of Chiropractic Corporation.
I asked Robert to take a look at this here because there's been quite a few discrepancies with the law around chiropractic corporations. Currently, the BNP code states that you must have the name of the chiropractor and corporation in there, and there's a lot of chiropractors that are trying to avoid incorporating so they can have just a generic DBA or whatever it may be. I don't see why we should limit people if they are incorporated on the same level. We've got to make sure that we're not opening up Pandora's box and having the Wild West, but it seems like those people that are incorporated tend to be a little more established, and I think we're going to have less problem than just people that are doing a DBA under whatever names that they want. But what were you able to find out?
Well, I discussed this with Ken. The interesting thing is because this hadn't come up, and I was wondering, well, what do other boards do? And I was also wondering what the overarching law, because the Moscone-Knox Professional Corporations Act, I thought maybe that's where this came from, is that they have a requirement for professional corporations. However, they don't. They defer to the appropriate regulatory board to address the issue. And then I was looking at other professions, and a lot of other health professions, and here's Pandora's box may get opened, they require for corporations as well as licensees that they register fictitious business names. So anybody, it's interesting that our board, way back when, I think it was in the 70s, that this provision went in the BNP code. They applied this to professional corporations, but not to licensees in general. Yes. So we were looking for historical information on this, and I haven't had a chance to speak with you since then, Kenneth.
Well, I did go back to the Senate bill that created Business and Professions Code Section 1054. It was an omnibus bill drafted by a committee, and it was intended to consolidate non-controversial provisions relating to Department of Consumer Affairs programs. I read the bill analyses, but because it was a committee bill and non-controversial, there wasn't really any specific detail in the bill analysis or legislative history about why specifically the legislature did what it did with regard to chiropractic corporations. Generally speaking, there is a distinction between a corporate entity and an individual doing business under a DBA. The corporation is a separate artificial person created by statute. There's a greater possibility of public confusion in situations involving corporations. Also, there's the shield from liability that exists when there's a corporation or corporate entity as compared to a DBA. When someone is doing business under a fictitious business name or a DBA, it's them doing the business, and so there's individual liability that is absent in a corporation. And so those are the kinds of reasons why the legislature may have imposed this obligation.
But that doesn't really hold true when we're dealing with professional corporations and licensees, because it's still going to be held right to the individual. You can't have a chiropractic corporation without a professional chiropractic license. So I think I understand what you're saying in regards to corporations or corporate law in general, but when you're dealing with a professional corporation, you're still bound by it. There's really no corporate veil of protection for us.
Well, there is to some degree, and that's one of the reasons why there are separate there's a separate requirement for insurance and other technical things that have to be in place in order to comply with Moscone Knox. And I think that the legislature has weighed in on this by passing the bill.
But is it not just the chiropractic profession that's bound to the restriction of naming of a corporation?
The Moscone Knox Act addresses all health professions, professional corporations. The Section 1054 and the surrounding sections in the B&P Code are specific to chiropractic. So they, and looking at Moscone Knox, they didn't specifically, they prohibit, I have to refresh my memory now, they prohibit a professional corporation from I'm sorry, I have to look that up. But they essentially, this issue that we're speaking about, there it's not prohibited by Moscone Knox, and they specifically refer to the individual licensing entities to address this. So the bottom line is there doesn't appear to be any overarching law that requires us to regulate the names of corporations, professional corporations, any more than we do the names of individual licensees. What we would need to do is amend or repeal Section 1054 of the Business and Professions Code. So, and then, I don't know, then we might find out from the legislature or from other interested parties if there are any objections to doing so.
Is this something that you want to pursue in the enforcement, or you want us to pursue in the licensing committee?
I mean, either way, I'm just, I think parity is important.
Yeah.
And it seems, some licensees brought it to my attention. And
There's always been confusion about it. They ask us about it every time we're out in public. So you want to deal with this in the enforcement committee?
How
and see
difficult
how
is
you
that to
can
repeal
deal?
that, Robert?
It wouldn't be difficult unless there was opposition. So it's simply going to the legislature and finding a legislator who'd be willing to carry the bill. If it's non-controversial, which it may be, one of the B&P committees may carry it in an omnibus bill, most likely Senate B&P.
Senator Hill's still in there. Right?
Yeah, so we could approach them and ask them, and if they if it goes in an omnibus bill, it would have to be non-controversial. So if somebody did raise opposition, they'd have to take it out of there, and we'd have to put it in another vehicle. So because opposition doesn't necessarily mean we can't move forward, but
With everything else we have going on, how time-consuming would this be?
not incredibly. This is nowhere near as time-consuming as regulations.
Dawn, is that anything that's been?
It's come up. Our members are confused. They haven't said what they want out of it, though.
They want to be able to name their corporation whatever they want. That's the thing. Yeah.
So we would be.
Is that something you guys could help with?
Sure.
Do we want to refer this to a committee
Yeah,
to discuss, and then we could get input from
Well, I don't know.
stakeholders?
I'm not sure how much there is to discuss. I think it would be get the ball in their
Well,
way.
I'll need to have, if we're going to submit something to the legislature, I'll need to have language that's approved by the board. So if you want to adopt that now, if you want to, or if you just want to repeal that section and then direct me to take the matter to the legislature, I can do that.
Yeah, I mean, if it seems to be redundant and it's just it's putting a stopgap measure, which without any necessity on our profession and not on others, I don't see what the need for it is. I haven't read 1054 in entirety, so maybe we need to do that.
Oh, it wasn't.
I didn't see it in here.
It's on there. I know I had that document. Oh, you know what? I think it's in my bag. Give me just 1 minute because I had some information about this issue.
And is that something that we want to approve or have the CCA take it on?
We're happy to help.
that's right.
I could look it up on my phone.
When yeah, it's a very short section,
Thirty.
but I had
I'll email.
done some research
What's
on this
that?
previously.
I'll send it to you right
I think it would be easier.
So can we agree that this is something that we do want the board to move along with, and Robert can work on appealing that section, but if he needs guidance from the licensee to refer it to the enforcement committee.
Yeah, if anything comes up that's a potential roadblock, we may have to bring it back to the board. But for right now, if you want to vote to pursue legislation to repeal that, we can do that. Because yeah, I apologize, I don't have my research with me, but the section itself is essentially the section just says that a chiropractic corporation, the name must include.
Shall contain
The name of the chiropractor,
If that's all it is, I
chiropractic,
know it.
and corporation,
Yeah.
basically.
Yeah.
Okay.
And so it's and then beyond that you can add other things in there, but it has to contain that.
Okay.
So
I'm
but,
sorry, I'm very familiar with that.
Yeah, that's the section,
Okay.
and so
And it's not gonna, we've talked about how many things we have going on, and I wanna make sure we're not diluting resources. It's gonna,
Well, once again, I mean, if we could get help from the CCA, like we get help from the schools.
well, legislation is, regulations. There's we have to carry all the weight on that throughout the whole
Do we?
process.
Right.
Legislation, if we find somebody to carry the bill, we may have to answer some questions, provide some information or documentation, and then we would go testify. It's not a consistent heavy workload.
so do we need to make a motion? Ken?
Yeah, it would require a motion.
Okay.
So I'll make a motion that we institute whatever measures we need to repeal section, BMP section 1054.
I'll second that. Any discussion amongst board members? Any public comment? Call for the vote,
Ezlino, yes. Dane?
yes?
Lickman?
Yes.
McLean?
Yes.
Gordon?
Abstention.
All right, let's move on to number 25, review, discussion, possible action regarding SB 1480.
So the next three items, I just want to inform the board that nothing has changed since the last board meeting. All those bills are all in appropriations committee.
Okay. So that's for 1054, for 1480, 1448, and 2138.
Correct.
And there hasn't been any change to the
2138
language
was
of
amended,
2138.
but nothing that would substantively change the board's position.
Okay. Alright, any public comment on those three?
Excuse me.
Okay, so number 28, update, discussion, and possible action on pending rulemaking.
So before we, if we want to have a conversation, but before we engage in a conversation about reprioritization, I just want to inform the board that shortly after our last board meeting, we were informed by OAL that our application in CE Reg was approved, and so that will be effective October 1st, 2018. So
And how long did that take?
very long, over 2 years. And
Okay.
so as far as staff and how we're allocating resources prior to any type of reprioritization, we've spoken with legal counsel, and we are working with legal counsel to move forward our delegation and also our CPEI regulations. Our retired annuitant is working on combining the uniform standards and disciplinary guidelines. The licensing committee is working on CE, and our new policy analyst, Andrea, she's working on looking at curriculum. So
the CPEI, the uniform standards, those are legislative mandates, right?
yes,
So we don't have much leeway with not making those
Correct.
priorities. And then the next one, delegation of authority to the
It's a really
assistant
small, insignificant package, so.
EO. Okay. And then CPR we're including with the CE.
Correct.
And so that brings us down to the curriculum requirements.
Correct.
So, so your suggestion for delegating resources so that we can have more attention on the curriculum requirements, given that the CPEI and uniform standards and disciplinary guidelines are legislative mandates, what's your suggestion?
So we've already submitted those two packages to legal counsel for review. And so they're with Ken, and Ken will review those and we'll move them forward accordingly. So he'll make a suggestion for changes and we'll bring it back to the board for approval. Once the things are changed, then we'll notice it, and those packages, the review period will start. So that will happen without any major additional work by staff. And so those are those two regulations. And then our retired annuitant is working on the disciplinary guidelines and uniform standards. A lot of work has been done on them already, so there will just be refining and kind of a fresh look at the regulations, because it's been about 1.5 years since anybody substantially dug into and worked on those regulations.
And also, there's a renewed focus on the uniform standards for substance abusing licensees, and so those requirements will likely be changing. So hopefully, the timing will coordinate, and those changes will be made before or as we're going forward with our regulation.
And there was some needs expressed in the board meeting today about revisiting our guidelines, our disciplinary guidelines. So that might need to be done in the enforcement committee to give the retired annuitant information on that as well. Yes.
Yeah,
okay.
Yeah, at some point. I think as far as process goes, we'll probably let her finish and do all the work, and then it's just the changes that will be done in enforcement committee will be won't be as labor intensive, so it'll be easy to incorporate those changes on the back end.
And then you said the delegation to the assistant executive officer will be small and hopefully
Yeah,
relatively
and that
easy.
one's already with Ken.
And so we can put most of our resources into CE and the curriculum requirements.
Correct.
Good. Wow.
So Andrea's already started reviewing curriculum. We've been working on that for about the last 10 days. So, with the help of the newly appointed committee, we'll be able to make some progress on that regulation.
Okay. So as far as I see what's going on here, I don't think, well, besides getting rid of that CPR, because that's going to be folded into the CE regs.
Correct.
That'll move the curriculum requirements up, and other than that, things can kind of stay how they are.
Correct.
Except for, I want to discuss G is on there, chiropractic records retention, disposition of patient records. That is above right now, continuing education requirements, and I think those should be switched.
Okay.
So, because what we're really working on right now is curriculum and CE. Yeah. Okay. All right. Any discussion? Any public comment? Okay, we'll move on to public comments for items not on the agenda. None? And future agenda items? Wait.
I did have one. On the CE regulations, you had 2 work groups from Northern and Southern California. Could you make that public to the CE providers, and so that they have good input from the experts and when they're looking at the regulations?
What is it
Repeat
that you would like public?
The records from the work groups that worked on the CE regulations.
So
Yeah,
I think we had
well,
the
we
focus
have-
group
we
for
have-
curriculum.
I'm sorry?
We didn't have focus groups.
We had focus groups for the CE providers and specifically for the requirements for being a CE provider. Because right now the very issue we've been discussing this year is that we have no specific requirements that have to be met before you can be certified or authorized to be a CE provider. So we had those focus groups to get feedback. Yes, we can make that public I'm certainly we can share it with you. I don't know if out of context it would be something we'd want to put on our website because people might not, it's all just
Right.
a compilation of people's comments. And so, but if you want to follow up with me or Marcus, we'll
Okay.
share that information with you.
And then are you planning on having some work groups on CE content?
We likely will. I mean, we've still got a lot of work to do, and so at some point, because we want to have a pretty well developed and your product going forward. When we get to the formal stage, we want to know that we've already heard everybody's concerns and made every attempt to address those, and so that we can take care of those things on the front end rather than having to do multiple renotifications of the regulations. So we do want the input, and we likely will have focus groups as an efficient way of getting that feedback once we have something formed that we think is ready for people to pick apart.
Okay. Then some of the CE providers have been having problems with staff going through the application or the outlines hour by hour and saying that's not technique, that's exam. Sometimes some of the techniques have specific exam procedures. Say CBP, DNFT, activator, NUCA. So they're not exactly exam procedures, they're part of the technique evaluation of the patient. So people are having to submit separate applications. So you have a 12-hour program. Staff says, no, that's an exam or part of the physical exam. When it's actually patient evaluation that is part of the technique, specific to that technique. So we have to submit an application for just that 1 hour.
This is coming up in the context of public discussion, so we can hear what you have to say.
Mhm.
The board cannot discuss it because it
No.
hasn't been agendized.
Right.
It could be the subject of a future agenda item, but because of the time constraints, what we might ask you to do is just summarize whatever concerns you might have in the form of what could be added to an agenda item.
Okay. Yeah, it's just that all of these applications, we're killing heck of a lot of trees. You're probably taking a lot of room for storage. We're having to pay multiple fees. It's like, let's cut it down and do one application for all of the different topics, like most of the other boards do, and just raise your fee. So it'd simplify and streamline the process.
Any other public comment for items not on the agenda? Future agenda items?
I have one. I think it would be good for our board members. I mentioned it before. So this could either come from you, Mr. Swenson, our legal counsel, or we bring in some legal counsel to give a little training on just appropriate receiving and giving testimony. And certainly, stemming around some of the questioning that we ask the petitioners. I think there are some better ways that we can be interfacing there. So a little guidance in that area. There are some good books out there on giving testimony in court that could be helpful if we can't do it on a public venue here. We could just, I could direct a couple books to you that you could disseminate to the board.
Is this board members testifying or board members receiving testimony?
Receiving testimony, but obviously if you testify, it's going to all fall into the same category. For instance, we shouldn't ask questions that we already know the answer to or leading questions of the petitioners and whatnot,
All right, I would certainly be able to do that.
I just realized that, today and times in the past, we've cut off the petitioners when they're speaking and we've asked them to not do the same to us, and it'd be a good idea to exert the same level of courtesy.
Any other future agenda items? Okay. Meeting's adjourned.
All right. You guys want these?
5